All right, guys, let's go ahead and get started here. My name is Missy Longgrass. I'm a professor at LSU. I've been teaching sales, obligations, contracts for about 8 years now. I'm going to be walking you through the first portion of the Code 3 exam. So I'll be here with you for the next 3 days. And then during that time, we're going to be covering obligations, liberative prescription, contracts, sales, and leases. And then after I leave, you're going to have another day on Code 3 with Jason Kilborn. He's going to cover security devices with you. In all, that's going to be a total of 4 days on Code 3. You know that already from looking at the schedule. That might seem like a lot, but I want to underscore for you that this kind of in-depth and lengthy treatment of Code 3 is incredibly necessary and totally worth it. I'm not going to sugarcoat it. The Code 3 exam is very difficult. It is one of the most difficult portions of the bar exam. It historically has a low pass rate. The material is dense. It's full of all kinds of arbitrary time periods and complicated form requirements, a lot of stuff you have to memorize. This is not the exam that you want to skimp on. This is not an exam for which you can know the gist and be okay. You need to know the details here. But that's okay, because we're going to spend a lot of time in the next couple of days trying to make this information really memorizable. We're going to break it down and make sure that you can make it manageable for yourself. Now, before we get started today, I want to make sure you have my contact information. I'm sure you have it somewhere in the Barbary materials, but my email address is on both of these boards. It's missy.longgrass@law.lsu.edu, missy.longgrass@law.lsu.edu. That's the best way to reach me. Please email me. I'll get back to you within 24 hours in almost every case. I'm happy to answer any questions you have about the lectures or about the outlines as you're going back through them, or any of the old exams or model answers in the testing volume. So feel free to email me anytime. Now, as I said before, we're going to progress through this material today with me in 3 days. Excuse me. We're going to cover today liberative prescription and obligations. Tomorrow we're going to cover contracts, and then on day 3 on Wednesday we're going to cover sales and lease. Right, so that's the plan. Go ahead and get out your liberative prescription outline, and I'm going to be giving you some more sort of introductory material as we get sort of set up to start liberative prescription. The first thing I want to say is that we're going to be covering this material today, liberative prescription and obligations, in 3 segments, 3 roughly hour-long segments. For those of you who watch the clock for the breaks, I just want to give you a heads up that it'll be a little over an hour for the first 2 segments, and the last segment is shy of an hour. So I'll try to give you some more signposts about when you can expect me to stop talking before every break. I know you're looking forward to that every time. All right, and also, by way of introduction, I want to talk a little bit about the Code 3 test and the Code 3 examiner, right? So you may know that we have a new-ish examiner for Code 3. He's written a number of, I think, 3 or 4 exams at this point. And you know, there's some good news and bad news here. The good news, if there's good news to share, is that his exams are not all that different from the old examiner's exams, which means that all of the old exams in the testing volume are really useful for you as practice tests, right? So don't feel like you have to limit yourself to the most recent exams in the testing volume. The bad news is that this guy is brutal. He's just as brutal as the last guy. He asks hard, long questions that are difficult to answer in the time allocated. He wants you to give him all of the information that you know about topics and to engage in really detailed and nuanced fact analysis, right? So you have to be really on your game for this test. One other sort of piece of good news or silver lining here is that we know how he's going to test. We can generally predict the way he's going to allocate points. He's been fairly consistent, and even just in talking with me, I'm a member of the advisory committee to the Louisiana Committee on Bar Admission, so I chat with the examiners regularly throughout the year. He's indicated that he intends to allocate points roughly like this: 25% sales, 25% lease, 25% security devices, and 25% obligations and contracts, right? So again, 25% sales, 25% lease, 25% security devices, and 25% obligations and contracts. So of course, I cannot predict the future with certainty. I would never guarantee you what the exam will look like. But generally, I think it's pretty typical that you'll see a big sales question, a big lease question. Both of those questions will have obligations and liberative prescription issues like embedded in them, right? And then you'll have a big security devices question. And then the multiple choice will be the sort of gamut of everything, right? All right, so another thing that I want to underscore as we begin our discussion of the material today is that in looking at the old exams and talking with the examiner, it is very clear to me that what this examiner likes to do is see you argue both sides of an issue. He likes to see you engage in detailed, factual analysis, right? Is this seller in good faith or bad faith? Here are all the reasons why the seller could be in bad faith. Here are all the reasons why the seller could be in good faith. Here are all the consequences if the seller is in bad faith. Here are all the consequences if the seller is in good faith, right? You can see back and forth. I'm going to try to point out to you as we go through the material some of the topics that are best suited for those kinds of analysis, where he tends to call for those kinds of analyses. So look for that. All right, finally, I have a note on the multiple choice questions. You may have heard about this issue from some of the other lecturers. In your testing volume, you're going to see in some of the older exams, multiple choice questions that are rote, black letter law style multiple choice questions, right? The old exams in the last 5 or 6 years, old exams use that kind of questions. Those kinds of questions are being phased out on the Louisiana bar exam. The examiners are using more fact-based questions where they give you a little hypothetical and then you have to apply the law and determine what the appropriate answer is. So watch out for that. When you're looking at those old rote memorization style questions, they're good for drilling, but they're not representative of what you're probably going to see on the exam. Barbary has written some questions that they believe to be more representative of what you're going to see on the exam, and some of those appear in the testing volume. So those are good to look at to get an idea of what the MCQs will be like. All right, so that's enough introduction. Let's get right down to liberative prescription. Make sure you have your outline out. Also make sure you have out your handout. I'll be sort of pointing out information that you need to sort of fill in the blanks in the handout. And almost every hypo that we do today appears in the handout. So you can write down the answers, and then when you're looking back over them and you don't know what the heck the answer was, you can email me and I'll email and talk with you about it that way. All right, so first, liberative prescription. Liberative prescription, guys, of course, is Louisiana's version of what the common law calls the statute of limitations. Now, look, if you're not Louisiana trained, if you didn't take the civil law courses at a Louisiana law school, the only hard part about this is that you need to familiarize yourself with the terminology, right? The terminology is different. Terminology, guys, is super important on the code sections of the bar exam, right? The bar examiners are all about weeding out the common law folks, right, who don't know anything about the civil law. So don't trip up and use common law terminology on these civil code exams. So pay close attention to the differences that I'll be pointing out to you. And for one thing, don't you dare write statute of limitations on the Code 3 exam, right? It's liberative prescription. Now, we're going to start with some basic definitions. The word prescription by itself with no modifier whatsoever, right, means the effective time on legal rights. The effective time on legal rights. Write it in the handout. And there are 3 types of prescription. 2 you've already reviewed in your Code 1 and Code 2 sections. These are acquisitive prescription, right, which is a method through which you acquire ownership or another real right through the passage of time. Acquisitive prescription. And there's also the prescription of non-use, right, which is the loss of a real right through the failure to exercise it. Right, now, both of those types of prescription, they deal with property rights, so they're very unlikely to come up on this Code 3 exam. The one that we're more concerned with and what the lecture will focus on today is the liberative prescription. Right now, again, focus on writing down those definitions in full in your handout. You got to be able to regurgitate these definitions on the bar exam, right? All right, so let's do another definition. Liberative prescription is defined as the barring of an action through the passage of time. The barring of an action through the passage of time. Now, of course, liberative prescription could be tested pretty much anywhere on the bar exam, right? Statute of limitations could be anywhere, but typically it's tested in the Code 3 exam. So in the Code 3 exam in particular, you want to keep your eyes open and be aware of potential prescription issues. And in the past, guys, liberative prescription has been tested in a number of different ways. One way it's been tested in the past, and if you look in the testing volume, you will see this, is in a sort of rote memorization kind of way, right? Explain the differences between liberative prescription, the prescription of non-use, and acquisitive prescription. Right? That kind of question isn't too likely to come up anymore. Again, the examiners are pushing more toward application-based questions. Also notice that question is really beyond the scope of the Code 3 exam, right? Because it's explicitly asks you to talk about property concepts. Now, that might seem like it's unfair, right? But we do see this from time to time on the bar exam. In fact, it's not all that infrequent that examiners ask questions, whether intentionally or accidentally, about material that falls outside the scope of a particular exam. And, you know, those of you who are trained in the civil law know, because of the way our code is interconnected, some of that is unavoidable. But if you see a question like that, don't panic. Try to focus on the material that is really supposed to be tested on that exam and give as much as you can recall for the others. All right, so liberative prescription operates just like the statute of limitations and the common law in that for various causes of action, there's a specific time period, right? And if you don't assert your action within that specific time period as a plaintiff, then generally your claim is barred, right? I say generally because there are some exceptions to this, and we're going to talk about those exceptions momentarily, right? But typically, you have a statutory period, and you have to assert a claim in that period, or you're out. Now, if your job on the exam is to figure out whether a claim is made timely, right, then you're going to need to know how to count, how to calculate the time period. So how do you do that? Look at letter C in your outline on page 1, computation of time. Now, you'll notice in C2 and C3, we have two different rules here. Actually, let's back up and do C1. Let's do the general rule. The general rule under C1 is that prescription begins to accrue on the date the cause of action arises. On the date the cause of action arises. Now, this is the general rule, guys, and in real life, attorneys have a hard time figuring out exactly when a cause of action arises. But on the bar exam, this isn't too much of a problem because most of the prescriptive periods that we're going to cover tell you when prescription begins to accrue. In other words, we tell you in the prescriptive period itself when the cause of action arises, right? So don't worry too much about C1. That's why I almost skipped it. All right, C2 and C3 are far more important. This is about actual counting. We have two different rules here. One for calculation of time in a period that is computed in days, and another for a period of time that is computed in years. And here's the thing, guys. All of the time periods that we're going to talk about today are periods that are computed in years, right? They're years periods. So focus on C3. C2, read the rule a couple of times. C3, that's where it's at. The years rule is this: if a prescriptive period consists of one or more years, prescription accrues on the day of the last year that corresponds with the commencement of prescription. Right? That's what goes in your handout. On the day of the last year that corresponds with the commencement of prescription. All right, so let's do our hypo that's in the handout. This is our first hypothetical of the day, bottom of page 1. Let's say that Jack sees Jill in the hall on January 1st, 2016, and he punches her in the face, right? Punches her in the face, January 1st, 2016. Now remember, delictual actions like this one are subject to a 1-year prescriptive period that commences on the day of the injury. We're going to talk about these periods in a little while, but just remember for now it's a 1-year period. So if we determine that the cause of action arose on January 1st, 2016, right, the day of the injury, how do we count? Well, we have a 1-year period for delictual actions, right? It's a period that's counted in years. We start on January 1st, 2016, and we end on January 1st, 2017, right? So that's the answer for the hypothetical, January 1st, 2017. Now notice, technically, we get the same date twice, once at the beginning, once at the end. It's a year and a day. Don't overthink that, right? It's just the way that we do it for ease of calculation. All right, now, you might be asking yourself, why did this crazy lady just give us a hypothetical about torts when this is a contracts exam, right? Well, it's not a contracts exam, it's code 3, and it includes obligations, right? Obligations of all kinds. And one kind of obligation is a delictual obligation, right? So although this is not the torts section of the bar exam, you will occasionally see torts issues cropping up on the code 3 exam. Don't panic. For the love of God, don't engage in duty risk analysis on this exam, but be prepared to talk about the obligations and prescriptions issues that you might see in torts questions, right? And I'll point out a couple of other tort things that come up from time to time in this exam. All right, the next topic in your outline, letter D, is really important, contractual freedom to modify prescription. Most of the rules in the code, guys, are suppletive rules. You remember what that means? It means they can be contracted around by the parties, right? Suppletive rules. But there are some rules in the civil code that are imperative or mandatory, right? They cannot be contracted around by the parties. And with respect to prescription, we do have some public policy limitations at play, right? The parties are not completely free to modify the rules of prescription however they wish, right? The effective time on legal rights is considered to be a matter of public policy, right? And so we have principles at play here that limit the parties' contractual freedom. What's the big idea? The big idea here is that the purpose of prescription is to promote finality, right? We want there to be finality on causes of action, some period of time beyond which everyone can be assured that no suit will be brought. All right, so let's pay close attention. There have been big legislative changes here fairly recently, 2013. The examiner didn't test these legislative changes right away, right after the law was changed, which was kind of surprising. So they're still kind of on the table, right? The examiner at any moment could decide to give a question that really heavily focuses on these rules. All right, so first, parties to an obligation may not exclude prescription. That's what goes in the handout, circle, may not exclude prescription. Liberative prescription always has to apply in some form, right? The parties can't get rid of it completely. Second, parties generally cannot lengthen the prescriptive period, right? Can't make it longer. Again, this is just an outgrowth of that finality idea, right? We don't want to draw prescription out indefinitely, causing instability. But there is a major exception to this rule now, and this is where the law is new, right? An obligor can grant an extension before prescription accrues, right? So before prescription accrues, an obligor can grant an extension. Now there's a whole bunch of stuff here in the detailed outline on page 1 and top of page 2, but I want you to remember really just two big ideas about these rules. I think you'll be okay if you know these two big ideas. Write this in your handout. Parties to an obligation may lengthen prescription provided that 1, the extension does not exceed 1 year, can't exceed 1 year, although successive extensions can be granted year after year. All right, so that's number 1, can't exceed 1 year, but successive extensions can be granted year after year. And number 2, the extension has to be express and in writing. Express and in writing. All right, I think if you know those two things about extension of prescription, you'll be good to go. All right, now look at number 3 in your outline. This one's a little bit tricky. It says parties cannot make the requirements of prescription more onerous. We do not allow parties to make prescription, quote, more onerous. What does this mean exactly? Well, it can be difficult to know. In fact, this idea of more onerous has caused the courts quite a lot of headache over the years. This rule makes sense in the context of acquisitive prescription, right? So the parties can't agree, for example, for 30-year acquisitive prescription that just title and good faith are required, right? That would make prescription more onerous. It's a little harder to apply this rule to liberative prescription. Obviously, making prescription longer makes prescription more onerous, right? At least for the obligor. But that can't be what this rule is relating to, because now we have a specific set of rules on lengthening prescription, right? And the specific set of rules we just covered on lengthening prescription govern here. So maybe this rule that we can't make prescription more onerous prevents us from shortening the prescriptive period, right? That would make prescription more onerous for the obligee, right? It's a shorter period of time within which to sue. Here's the deal, guys. There's a circuit split on this. The courts cannot agree about whether shortening the prescriptive period violates this rule that prescription cannot be made more onerous. So in the handout, I've given you an opportunity to circle maybe, right? In other words, is this a violation of the rule that we can't make prescription more onerous, shortening prescription? Maybe, right? The courts are split. That's what you should write there. The courts are split. Now, frankly, guys, this is something that, in my opinion, would go beyond the scope of minimum competence, right? The bar examiner should not be asking you questions about things that are subject to complicated circuit splits where you'd have to explain all that stuff in an answer to the bar exam. Nonetheless, right, the examiners routinely ask questions that are beyond the scope of minimum competence, whether intentionally or, more commonly, accidentally, because they don't appreciate, right, the full complexity of a particular issue. Anyway, if you know that generally the courts are split on this issue, you should be okay. All right, next, we need to talk about renunciation of prescription. This is letter E on page 2. Renunciation, guys, is like waiver at common law. So if you're common law trained, it's like waiver. But common law people, you will not say waiver on this bar exam, right? You will not use common law terminology. You will use the term renunciation. So renunciation is when you give up the effects of prescription, right? And technically, and this is the definition that is the term of art, abandonment of legal rights acquired through the accrual of prescription. I'll say it again. Renunciation is the abandonment of legal rights acquired through the accrual of prescription, right? When prescription is renounced, it is as though prescription never ran, starts all over again, commences anew from the time of renunciation. All right, now the first thing that you need to remember about renunciation is that it can't occur unless the prescriptive period has already accrued. Right? Already accrued. The period has to be complete and the action barred in order for there to be a renunciation. In your handout, I want you to write in the words that are missing here. After prescription has accrued in a party's favor, he may renounce it. And we also need to remember the effect of renunciation, right? After it is renounced, prescription commences to run anew from the time of renunciation. That's what goes in the handout. All right, now, because renunciation is so serious, right, starts it all over again, the only way the debtor can renounce prescription is through very clear activity evidencing his desire to give up the benefit of prescription, right? This is not an inference that we're going to draw lightly from factual circumstances. Now, we need a clear intent to renounce, but we don't generally require any particular form, right? It doesn't have to be in writing as a general rule. But there is a super important exception here that is tested all the time, right? A promise to pay a prescribed debt must always be in writing. I'll probably say that 7 times today. A promise to pay a prescribed debt must always be in writing. So again, this is what goes in the handout. Although renunciation may be express or tacit, a promise to pay a prescribed debt must be made in writing. All right, let's do a hypo. Jack owes Jill a debt of $100. The debt was due on January 1st, 2012. On January 1st, 2016, Jack calls Jill on the telephone, apologizes for never paying, and promises to pay the debt in full. Has prescription been renounced? No, right? The answer is no. We have a clear, explicit promise to pay after prescription accrued. And by the way, guys, this cause of action was subject to a 3-year prescription, which we'll talk more about in a moment, right? Prescription ran on January 1st, 2015. After prescription accrued, Jack calls and promises to pay, but because this is a prescribed debt, right, a promise to pay must be in writing to be enforceable. Now the hypothetical asks you, hey, would this be different if he had promised to pay in a letter? Sure, absolutely. Now our writing requirement is met. Prescription would be renounced. It is as though prescription never accrued, commences anew from the time of renunciation. You got it? All right. Now those are all the basics. Now we're going to talk about the liberative prescriptive periods. These begin on the bottom of page 2 of your outline, and this is going to be painful, guys. It's just tons of periods, rote memorization. This is boring, but it is easy. So it's where some low-hanging fruit lies. Now most of the important periods that you need to know, in fact, I think all of the ones that have been tested in recent history are in your detailed outline. In the handout, I've pared it down even further for you, focusing on the ones that are tested the most frequently, the ones you really need to know. So the biggies are kind of in the handout. All right, first, 1 year periods. 1 year is the prescriptive period for torts, right? Delictual obligations. Again, the 1 year period begins when the injury occurs, subject to those counting rules that we talked about earlier. If an injury occurs on, June 6th, then prescription accrues on June 6th of the next year, right? Now look, you can see there's a special rule here at the top of page 3 for immovable property, damage to immovable property. This one goes in the handout, believe it or not. It's important because it's been tested before on the Code 3 exam. An action for damage to an immovable is subject to, again, a prescriptive period of 1 year, same period here, but we don't begin with the injury for damage to immovable property. We say prescription begins to run on the day the owner acquired or should have acquired knowledge of the damage. So when the owner knew or should have known of the damage, that's when prescription begins to run. All right, now again, you'd think this would be tested in torts because it's a torts kind of rule. But in the past, when it was tested on Code 3, it was tested in a kind of complicated hypothetical about some obligations existing between the owner of some property and some other people. And anyway, this person owned a home and some gravel was removed from the homeowner's driveway without his permission. That's a tort of conversion, right? And it's a technically damage to immovable property. That's a tricky way to set that issue up, but it was there. And again, watch out for some of these examples I'm going to be giving you from old exams. The examiners, routinely recycle questions. They routinely recycle questions. And the new examiner routinely recycles questions from the old examiner. Some of these questions that are being recycled are in your testing volume. Some of them are not. So I might give you hypotheticals from old questions, kind of jot them down. You might not find them in the testing volume when you go back because they might be too old. All right, now there's also a relatively new 1 year prescriptive period under number 2 here, referenced in your outline. An action against a home inspector for a claim related to a faulty home inspection. This 1 year period does not apply if there's been fraud. You'll recall there's a special prescriptive period for fraud. But absent fraud, 1 year from the date of faulty inspection. Guys, I can see this coming up in a redhibition question, right, where we have some kind of defective problem in a home and there's been an inspection and the inspector did something wrong, right? Now, does this homeowner have a claim against the inspector? Maybe, depends on if it's prescribed. All right, now there's also a 1 year period under number 3 for the revocatory action. If you don't know or remember what the revocatory action is, I'm not going to talk about it right now. We're going to talk about it tomorrow. Right, for now, just remember the prescriptive period is 1 year from the date the creditor has actual or constructive knowledge of the act, but never more than 3 years from the act of the debtor. Right, so 1 year from the date the creditor has actual or constructive knowledge of the act, but never more than 3 years from the act of the debtor. This has never been tested. Testable, of course, but never tested. All right, there's only one 2-year liberative prescription, fairly recently enacted. Claims for damages over crimes of violence. I cannot see how the examiner will test this on Code 3. It really doesn't belong in Code 3. Just watch out for it nonetheless. All right, the 3-year periods are far more important. We need to know these. They are tested all the time, right? 3-year periods here under letter C, memorize all of them. 3 of them are especially important, and these are the ones that are listed in your handout. Money lent, open accounts, and past due rent are subject to a prescriptive period of 3 years. The prescription commences when payment is exigible. That's what goes in the handout, exigible. That means due, right? So when payment is due, prescription commences. So for example, if you have a lease and the lessee, the tenant, fails to pay the rent, There's a 3-year liberative prescription on the collection of that past due rent. Prescription commences from the time each rent payment is due, right? So if a rent payment was due on August 1st, 2014, and it's not paid, then the action prescribes on August 1st, 2017, right? 3 years. Now the trick about leases, and you might see this on the bar exam, so pay attention, watch out for this fact pattern. With lease law, this exigible requirement means that when you have lease rent payments that are due on a month-to-month or other term basis, each payment has its own prescriptive period, right? So there might be many different prescriptive periods for the collection of past due rent in a particular lease, right? So if I owe rent every month and I don't pay for 6 months, I have 6 different prescriptive periods, right, running on the collection of the past due rent. Watch out for that. All right, the 5-year periods are also pretty frequently tested. You're going to want to read through these a few times. Probably the most important 5-year period that you're going to see here is for promissory notes, right? Promissory notes tested all the time on Code 3. In your handout, you're going to want to write down the 5-year period for promissory notes. Promissory notes, whether negotiable or not, and negotiable instruments have a 5-year liberative prescription. Again, prescription begins to accrue when payment is exigible or due. Now, with promissory notes, that means that the commencement of prescription depends on the kind of note that you have, right? If you have a demand note, right, you'll remember the obligee can demand payment at any time, and so prescription begins to run immediately, right, as soon as the note is executed. If you have a time instrument, on the other hand, right, where there's a term for repayment, then the 5-year period begins to run when the term is up, right? Whenever the term is up. So you got to figure out if your promissory note is a demand note or a time instrument in order to figure out when prescription runs. All right, let's take a short break from the time periods and talk about generalities here. And I'll sound like a broken record. I'm going to make this point about many aspects of the bar exam. So the directness with which the bar examiner asks about prescription has varied over time, right? And in some old exams, you'll see kind of rote memorization, black letter law kinds of short answer questions. What's the prescriptive period for this or that? You will not see that probably on the bar exam, right? It's all about application. But even with application questions, you can have different kinds of, setups. In some cases, the examiner throws you a softball, right? They sort of tell you in the facts very explicitly when some action occurred, and then they ask you whether the claim was prescribed. But more commonly what you have is a massive fact pattern, right? And there's a bunch of dates in it. And then the examiner asks you if there are any defenses, right? And there might be tons of defenses that are implicated by the facts, and one of them might be prescription, right? So watch out for that, particularly in questions about redhibition. This is where this comes up. Prescription and redhibition. The examiner asks you generally what are the defenses. There's a bunch. Prescription is one. The trick here, and of course you remember this from law school, is that if you see dates, there's probably a prescription issue in there, right? What are dates for on a bar exam? Prescription, right? And bar examiners are trained not to include dates that are sort of like arbitrary red herring kinds of facts unless they're going to be used for something in the fact pattern. So if you see dates, they're probably important, right? And again, what are they used for? Prescription. Try to see the prescription issue. All right, let's get back to the periods here. 10-year liberative prescription. There are 2 periods in this list that I want you to focus on, and these are the first 2 that are listed. The first one, guys, is extremely important, right? Often overlooked, but extremely important. Personal actions that are not subject to any special rule of liberative prescription are subject to a prescription of 10 years. So in other words, the default rule for personal actions is 10 years. Okay, so what is a personal action, right? Let's remember what we're talking about here. We are contrasting personal actions from real actions, right? Or actions to assert rights in property, right? This is not about a right to a thing. A personal action is a right against another person for a performance, right? In other words, said another way, a personal action is an obligation, right? So what's the upshot of this? The default rule for all obligations for every breach of contract is 10 years. So it's a very important rule, right? Now, we're going to talk about a lot of other specific time periods for special kinds of breach of contract. But just run-of-the-mill general breach of contract that doesn't have a special rule, 10 years, right? So you need to know that rule. The other big 10-year period that you need to know is the action against a contractor or an architect for defects, right? So if you want an action against a contractor or an architect for defects, the period is 10 years. This has been tested a couple of times in the context of requiring you to distinguish between whether a contract is a contract of sale or a contract to build, right? You might remember that issue from law school. We'll talk about it on day 3 when we get to sales, right? But when you decide that a contract is one to build and there's some defect in the thing that's been built, now you're going to have a cause of action against the contractor or the architect. Now, there's a little note here in your outline that I just want you to pay attention to, and that is that that this issue, this 10-year period, is actually beyond the scope of minimum competence, in my opinion, because actions against contractors and architects and other design professionals are actually subject to a really complicated scheme of time periods that are found in the revised statutes. They're preemptive periods, 5 years-ish for many of these claims. There's a lot of confusion in the law and the case law about how the 10-year period interacts with those preemptive periods. I wouldn't worry about that too much because it's not settled law, right? And so the examiner really shouldn't be asking you about it at all. If the examiner does, you should just say sort of something general like, hey, it's a 10-year period. There are some 5-year preemptive periods in the revised statutes. They might be applicable, and move on, right? There's no way you could do more in the time that you have available. All right, the other periods that are for 10 years here under E have never been tested. Of course, they are testable. They have never been tested. All right, and finally, suits to recognize succession rights and suits for student loans are subject to 30 years, never tested, right? Testable, but never tested. Big periods are the ones we've covered in detail. All right, so that's all the time periods. Now, let's talk about the circumstances that can affect the running of prescription, right? I told you earlier that generally, if you don't bring your claim as a plaintiff within the time allocated, your claim is barred, right? I said generally because there are exceptions. So here are the exceptions, right? There are 2. There's interruption and there's suspension, right? So that's what goes in the handout. There are 2 ways prescription can be delayed. Delaying prescription occurs through interruption and suspension. Now, the most important way that these 2 concepts differ is in their effects, right? You'll recall interruption causes the time period to be completely wiped out. It starts all over again when the period is interrupted, right? Suspension is different. It just hits the pause button, right? So it doesn't start over again. We just pause it and then we continue it, right, at some later point. I'll remind you of this difference again as we talk about each of these in depth. All right, let's talk about interruption first. Now, common law folks, listen up here. I think that this concept is one that doesn't have a really good analog in the common law. This is a kind of special Louisiana civil law kind of concept, interruption of prescription. Again, it's the complete restarting of the prescriptive period, the complete restarting of the prescriptive period. If you look at the detailed outline, you'll see a definition here. If prescription is interrupted, the time that has run is not counted. Prescription commences to run anew from the last day of interruption. I'll say that again. If prescription is interrupted, the time that has run is not counted. Prescription commences to run anew from the last day of interruption. Right? All right, so let's pause here for a second. Sounds kind of like renunciation. How is this different from renunciation? You need to be able to tell the difference between an interruption and a renunciation. With renunciation, you'll recall, right, the prescription has already run in full. Claim is barred, and then the debtor renounces prescription, right? With an interruption, prescription is still running. Hasn't run fully yet. Claim is not yet barred. And the debtor does something to start the prescriptive period over again, right? So the operative difference is whether prescription has accrued, right? So in the detailed handout, renunciation occurs after prescription has accrued. Interruption, on the other hand, occurs before prescription has accrued. All right, now there are 2 ways to interrupt prescription, 2 causes of interruption, if you will. these are the filing of a lawsuit and acknowledgement. Filing of a lawsuit and acknowledgement. All right, so the first and most frequent in real life method of interruption is the filing of a lawsuit. Right now, there's a little more detail here that you need to know. In order for the filing of a lawsuit to interrupt prescription on its own, the lawsuit has to be filed in a court of competent jurisdiction and venue. Right, so it has to be filed in a court of competent jurisdiction and venue. If suit is filed in Orleans Parish and the proper venue is Jefferson Parish, then the filing alone does not interrupt prescription. But the lawsuit can still interrupt prescription if it's filed improperly. How? Through service of process. Right? When the petition is served, then prescription is interrupted. That's the wrinkle there. Now again, in the real world, that's how interruption happens quite a bit. On the bar exam, the more frequent way that you see interruption occur is through acknowledgement of the debt. Right? Acknowledgement of the debt is how we see it on the bar exam. Acknowledgement occurs through conduct, words, or writings that somehow recognize the debtor's position as a debtor. Right? The idea is basically the debtor recognizes the validity of the claim, acknowledges I owe something, and in order to discourage the creditor from filing suit, in order to discourage litigation, then we say the acknowledgement interrupts prescription. We give the creditor more time, right, to collect. Now again, what are we looking for? Conduct, words, or writings from the debtor acknowledging the claim. All right, so here's a good example. This is in your handout. Partial payment of a debt or the payment of interest on a debt. Right? So if I owe a debt and I make a partial payment or I pay some interest, I've interrupted prescription. Guys, this is tested all the time, all the time. You should remember that the Louisiana jurisprudence on this is fairly liberal in finding an acknowledgement. Right? It's harder to find a renunciation has occurred because prescription is already accrued. But with acknowledgement, because prescription is still running, it's pretty easy to find that an acknowledgement has occurred. All right, here's the hypo in your handout. Jack owes Jill a debt of $100, right? The debt was due on January 1st, 2014, right? Remember our three-year time period here for money lent, right? So it was due on January 1st, 2014. Normally it would prescribe in 2017, right? Okay, on January 1st, 2015, Jack makes a partial payment, pays $5. Has prescription been interrupted? Yes. Right? Yes, prescription has been interrupted. This is an acknowledgement. The time that has run is not counted. It's wiped out. We start all over again, commences anew from the time of interruption. Now again, this is a debt and action for money lent, subject to a 3-year prescriptive period. So the action will now prescribe 3 years from the date of the partial payment, right? January 1st, 2018. That's what goes in the handout as the answer, January 1st, 2018, 3 years from the date of interruption through acknowledgement. All right, now something to notice here, again, the difference between interruption and renunciation. In order to renounce prescription on a debt like this one that has prescribed fully, right, if we had renunciation, we would need a writing. But because the prescription had not yet accrued when Jack made the partial payment, we have a valid interruption and the time period is extended, right? So that's how that gets tested from time to time, right? Period has not yet run and Jack does something that's less than a writing, it's an interruption, right? If the period has already run, Jack does something that's less than a writing, it's not a renunciation. Got it? Okay. All right, let's move on now to suspension. This is another way for prescription while it's running to be affected. But here, instead of wiping out prescription and starting all over again, suspension simply hits the pause button. Now, I've said that a couple of times. Don't say that on the bar exam. Loose language like hits the pause button drives the bar examiners crazy, right? Think about this for a minute. These people, and there are many people who are assistant examiners, right? Practicing attorneys who've signed up, giving of their time to read bar exams. These people are complete nerds, right? They're nerds, just like me, right? They care about the language. They want to get you, right, for all the little things that you say incorrectly. So you have to say the right words. Don't say pause button, right? Instead, you're going to say what I want you to put in the handout, right? The period of suspension is not counted not counted toward the accrual of prescription. Prescription commences to run again upon the termination of suspension, right? So instead of saying pause, you're going to say the period of suspension is not counted toward the accrual of prescription. Prescription commences to run again upon the termination of suspension. All right, now most of the causes of suspension are legislative. They're in a statute somewhere, right? First, suspension operates between members of certain favored relationships. And here with these relationships, suspension occurs for all causes of actions. Now there's a list in your outline on page 6. Prescription is suspended between the spouses during marriage, minors and parents, etc. You can read through those on your own. Let's do an example. Let's say that Jack punches Jill in the face in the hall on January 1st, 2015, right? So Jack is punching Jill on the face. 2 weeks later, they get married, inexplicably, right? They get married on January 15th, 2015. All right, then they get divorced a year later on January 15th, 2016, right? So prescription is suspended during their marriage, right? So we've hit the pause button. We're not counting that time. Marriage is the cause of suspension here. So because 2 weeks had accrued, right, prior to the marriage, we've got 2 weeks, and then we don't count the year that they are married, and then we commence again, right, after the suspension ends. And so when they divorce, she now has the remaining 11 months and 2 weeks to sue, right? So the time that her action will prescribe is now January 1st, 2017. Write that down in the handout, January 1st, 2017. Go back over it later. If you have questions about how you got there, email me. All right, prescription is also suspended in favor of minors against people other than their parents for certain causes of action. This isn't all actions, but it's certain causes of action, and those are listed here in your detailed outline. These are not all that likely to come up on the Code 3 exam, frankly. What is likely to come up is the thing under number 3 here, compromise, right? Compromise. Suspension occurs once an action is compromised, and if the compromise is ever rescinded or dissolved, prescription commences from the point of suspension, right? Later on, we're going to see there's a bunch of rules about rescinding or dissolving compromises. We'll cover that more in the coming days. And so you may be called upon to talk about this rule, right? If you see that there's a compromise and then later it's dissolved, now has the action prescribed. All right, now we need to talk about judicial suspension. This is the bottom of page 6. Now, even though the Civil Code says that prescription can only be established by legislation, the courts have created an exception to that rule, and that is contra non volentem. And guys, yes, you have to know the Latin for this one. Sorry, just memorize it. Contra non volentem. All right, so what's going on here? I've given you kind of a rough rule in the outline, and I'll give it to you here to write down in your handout, because this is actually pretty complicated in the case law. This is entirely jurisprudential. There's a bunch of cases that we can kind of put together to create the rule. It's a very fact-dependent doctrine, you might recall from law school. But the basic idea is this, right? And this is what's in the outline and what goes in the handout. The basic idea is that contra non volentem only applies in exceptional circumstances. Write that down, exceptional circumstances, such as when the plaintiff was prevented from enforcing his own rights for reasons external to his own will. I'm going to say that again. It only applies in exceptional circumstances, such as when the plaintiff was prevented from enforcing his rights for reasons external to his own will. But think of this in more simple terms. In exceptional cases, when a plaintiff just can't sue for some period of time, we give him a break, right? But it's really super exceptional, like super exceptional. Raised all the time in litigation, almost always fails, right? Almost always fails. If you see facts on the bar exam where it looks like the plaintiff has been prevented through no fault of his own from suing, right? People are defrauding him or beating him up, or, locking him up, right? Then maybe there's a contra non volentem claim, right? Mention it. But then also say, this is super exceptional. He's very unlikely to win this. even though this claim exists. All right, now one of the most famous contra non volentem cases is in your outline, Corsi versus State Department of Corrections. Guys, a note about cases. We try not to inundate you with too many cases in the Barbary materials. We only do this when the case is like the seminal case or when the facts are regurgitated or used a lot on the bar exam, right, and frequently tested. So this is one of those cases where it's like the case, right? So pay attention to Corsi. So in this case, you might recall if you read this in law school, an inmate was beaten up by prison guards, right, so badly that he was, very injured and he didn't know who he was for a long time. It took him a long time to recover and to file suit, right? He was basically entirely incapacitated by the fact that he was assaulted. When he finally filed suit against the Louisiana Department of Corrections, right, the Louisiana Department of Corrections said, oh, your claim's prescribed, right? The court said no. The Louisiana Supreme Court said that the Louisiana Department of Corrections couldn't hide behind prescription when it was their action that prevented the plaintiff from suing. But see how super exceptional this is, right? The state basically physically beating, into a state of incapacity, the plaintiff preventing him from suing, right? Many of the fact patterns on the bar exam are not going to rise to that level of exceptional circumstances. All right, now before we wrap up this outline and take a break, we have two more things to cover, peremption and conflicts of law. We can do this relatively quickly. All right, so first, peremption. Peremption is similar to liberative prescription, guys, but it's different. It's kind of like the statute of repose at common law, right? But don't say statute of repose. You're going to say peremption. And here's another little trick. Say peremption. It's not preemption, right? It's peremption. Two totally different things. Drives the nerds crazy when you mess that up, right? Peremption. Okay, so notice the definition here on page 7 of your outline. Peremption is a period of time fixed by law for the existence of a right. A period of time fixed by law for the existence of a right. The theoretical difference between peremption and prescription, guys, is this. Whereas prescription is the barring of an action through the passage of time, with peremption, after the time has passed, the right disappears completely, right? It's completely gone. Total finality is the policy behind peremption, right? Generally, it is impossible to sue after the peremptive period has run. Now, the best way to understand this is to highlight some of the differences, like differences in effects, between peremption and prescription. And you'll see this on letter B on page 7. So there are 3 ways that peremption differs from liberative prescription. All right, so first, as we've seen, interruption and suspension can mean that prescription ends up taking longer than the legislative period, right? However, preemptive periods cannot be interrupted or suspended. They cannot be. No interruption or suspension of preemptive periods. That's important. Now, another significant difference between the two has to do with something called a natural obligation. We're actually going to discuss this a little bit later today, but basically it's a moral obligation, right? And with prescription, a moral or a natural obligation subsists even after prescription has run. Right? So even though a debtor can't be sued because prescription is run, he's still sort of morally obligated to pay, right? But with peremption, that doesn't occur. There's no natural obligation that remains after a peremptive period. And finally, liberative prescription can be claimed only by the obligor as a defense to a suit, right? The court can't bring it up on its own motion. Only the obligor can claim liberative prescription, but not so with peremption. This is more like a public policy kind of rule. The court can raise peremption on its own. 3 important differences between peremption and prescription. All right, now under letter C here, last thing under peremption, this is something that I think actually is not super important for you, but I'll spend just a second talking about it. One tricky thing that happens all the time in real life is courts are called upon to determine whether a period of time for the bringing of a claim is prescriptive or peremptive, right? So legislature passes a statute, it says, the action for such and such is subject to a period of 3 years. Doesn't say it's prescriptive, doesn't say it's peremptive, right? So we don't know. And then we have courts trying to sort out which one it is. And generally, it's a policy-based analysis, right? Like how much are we concerned with finality for this kind of claim? And if we really want concern with finality, if we have a lot of legislative intent that shows that the legislature wanted the claim not to exist anymore after the period of time is over, well then we call the claim preemptive, right? But here's the trick about this. You're not going to be called upon on the bar exam to decide as a matter of first impression whether a period is preemptive or prescriptive, right? That's just not going to happen to you. And most of the periods that we're going to talk about are either explicitly called prescriptive or preemptive in the Civil Code, or case law has established this rather clearly for us. So be generally aware that this is an issue, but this is unlikely something that you'll be tested on the bar exam, right? This is more of a real life issue. All right, the very last thing we have to do is conflicts of law, right? Conflicts of law. We're almost done with prescription, guys. All right, now conflicts, God, this stuff is the worst, right? Don't we all hate conflicts? It's tricky, it's embedded in all of the individual exams, right? You know this already from some of the coverage of the other sections you've done. We need to know the conflicts rules for liberative prescription because it could come up. The good news is that it never has come up, actually. So this has not been tested, but it could, right? So you need to know generally what the rules are. Now look, I'm going to walk you through the material in the outline here on page 7 and 8, and then I'm going to give you a rough rule that you can use in case of an emergency, right? And that rough rule is what I'm going to want you to write down in the handout, right? No, I said the gist isn't really enough on Code 3, but I think for conflicts and liberative prescription, we can get close to the gist and have it be good enough. All right, but first let's walk through what the rules are. Under general conflicts of law theory, right, a prescriptive period is generally a procedural rule, right? So the forum usually follows its own procedural rules. And that's just the general rule of conflicts, right? The forum usually follows its own procedural rules. So what does this mean for us for prescription? Louisiana prescription law almost always applies, right? If the cause of action that you're being called upon to discuss is coming up in a Louisiana court, which it should be on the Louisiana bar exam, Louisiana prescription law is going to apply, right? Great, easy. Now, but there are some rules here that are the outgrowth of this theory. And it depends upon whether Louisiana substantive law is applicable to a particular dispute or whether another state's substantive law is applicable to the dispute, right? So first, if Louisiana substantive law is applicable to the dispute, then Louisiana prescription law is applicable to the dispute, right? So if we apply the substantive law, we're applying the prescriptive law, right? That's a clear rule. Second, even if we decide to apply another state's law, substantive law, to a dispute, we're probably still going to apply Louisiana prescriptive law, right? Why? Because it's a procedural rule and we're supposed to apply the procedural rules of the forum. But there are 3 exceptions here and they're set forth in the outline. All right, first, if the action would be barred in Louisiana but not barred in the other state, and there are compelling considerations of remedial justice to maintain the suit, then we apply the other state's law. Exception 2, if the action would not be barred in Louisiana, but barred in the other state, and there are compelling considerations of remedial justice to dismiss the action, then we apply the other state's law. And third, if the cause of action would be barred in another state by a period that is deemed substantive rather than procedural, and the plaintiff is not a Louisiana resident or domiciliary, then we apply the other state's law. I told you it was terrible, right? Bad. So here's the rough rule, right? Here's what you can remember if all else fails. Because really, guys, this isn't all that complicated. So remember this, Louisiana prescription law always applies unless, 1, another state's substantive law applies, and 2, compelling considerations of remedial justice require us to apply the other state's statute of limitations, right? That's what it would be in that case. So another state substantive law applies, and there are compelling considerations of remedial justice that require us to apply the other state's statute of limitations. I think you'll be okay if you use that rule. All right, so we're gonna stop here. We're gonna take a 10-minute break. I came in under time, right at an hour. Way to go, me. All right, so we're gonna take a little break and then we'll come back and pick up with obligations in general. All right, guys, let's get started again. We have prescription entirely behind us now. We are moving on to obligations. We're going to talk about obligations, the obligations outline for the rest of our time together today. And we're going to finish this outline today. All right, now, specifically here, we're going to be talking about obligations in general, right? Remember, conventional obligations or contracts, that's a different deal. We're doing that tomorrow. If you look generally over this outline, if you just kind of flip through the table of contents, you'll see there are 5 sections in this outline. Really, the first one's kind of introductory, so there's really only 4 big topics here. So this material isn't really all that bad. It's pretty straightforward stuff. If you are Louisiana trained, if you took obligations in law school, you'll recall the hardest thing about this is probably the stuff on solidary obligations, right? You'll remember that stuff is the worst, kind of, yeah. So, but the rest of it is pretty simple, and we're going to be doing some hypos to make the solidary obligation stuff more manageable. All right, so we're going to begin then with the introduction. Oh, and I should mention, if you're looking for the break, right? We're going to break right after we finish solidary obligations. That's going to be our second break of the day. It's kind of an arbitrary place to break, but you're going to be tired after that, so we're going to break. All right, so let's start with our introduction here on page 1. If you're Louisiana trained, you know what this obligations in general stuff is all about. But common law folks, listen up and pay attention to this point because it's important. You need to know that the law of obligations is the law that governs every obligation, right? No matter how that obligation is created, right? So I even have a place in the handout for you to write this down, every obligation, right? Because it's easy to forget that obligations law applies to tort, right? And that obligations law applies to quasi-contract. It's not just breach of contract that we're talking about here. Now again, typically, right, what you see on the Code 3 exam is breach of contract or quasi-contract, but occasionally you do see some tort issues, right? So don't be intimidated by that, just be aware that that's a thing. All right, so the first thing we need to do here is define the term obligation. Again, usually for some of these basic definitions, there's some points on the table for regurgitating the basic definition, right? So you'll remember that an obligation is a legal relationship between 2 or more persons, right? It's a legal relationship between 2 or more persons. One is the creditor, who we call the obligee in Louisiana, right? Louisiana terminology, obligee. And the other is the debtor, who we call the obligor. And guys, those of us who teach obligations, we use the terms interchangeably in class. I think I used the terms debtor and creditor in talking to you about prescription a little while ago. Don't do that on the bar exam. It's obligee and obligor, right? Obligee and obligor. All right, so this legal relationship between these 2 parties exists when, 1, the obligor owes a performance to the obligee, a performance, and the obligee has the right to compel performance, right? So again, the obligor owes a performance and the obligee has a right to compel. Said another way, the performance is legally enforceable. You could say it like that too, legally enforceable. All right, no matter how an obligation is created, whether through a contract or a tort, a sale, a matrimonial agreement, whatever, the obligations section of the code defines the effects of obligations, right? So we have effects of obligations here. These effects, they flow right out of the definition we just discussed. For the obligee, the effects are 2. First, judicial enforcement, and 2, the right to damages, right? The obligee has the right to judicial enforcement and to recover damages. Now for the obligor, the effects are a little simpler, right? Once the obligor performs or pays damages, he's off the hook. He's entitled to be discharged. That's the term of art, discharged, right? All right, so that stuff is all pretty straightforward. The next couple of things in the outline, D, E, F, these are all big picture doctrines that you might be called upon to discuss on the bar exam in a kind of tangential way. First, letter D, the duty of good faith. We are Louisiana, civil law jurisdiction. There's an overriding duty of good faith imposed on all parties in every obligation, right? Overriding duty of good faith. Whenever you see somebody acting out of spite or with an intent to harm the other party, it wouldn't hurt to say something like, this is a violation of the obligation of good faith, right? Everybody has an obligation of good faith. Now, many places in the law, and a couple we're going to talk about in our time together, have this idea of good faith built in, right? So measures of damages, the idea of good faith is built in. There are specific rules on this. Redhibition, the concept of good faith is built in. But it's not always built in. So if there's a topic you're discussing on the bar exam, there's no specific rule of good faith that's applicable. The general rule of good faith is always applicable. Now, one note here, and this is specifically for the common law folks, the last sentence of letter D, there is no unconscionability doctrine in Louisiana law, at least not in the civil code. It might exist in the case law, but it's not really real. It's not really a thing here. So don't talk about unconscionability on the Louisiana bar exam, right? At least not in the Code 3 section of the bar exam. No unconscionability. All right, there is a civilian doctrine called abuse of right that can be invoked in certain circumstances. This is letter E. And this has been tested before, guys, specifically, and almost always in the context of lease, right? So this is a doctrine that prohibits an obligee from asserting a legal right when the primary purpose of doing so is to injure or harass the obligor. I'll say it again. The doctrine of abuse of right prohibits an obligee from asserting a legal right when the primary purpose of doing so is to injure or harass the obligor. Now, there are only a few instances in which Louisiana courts have found an abuse of right to exist. It's kind of an exceptional doctrine. Again, we require that the primary or exclusive motivation of the obligee be to harm the obligor. As long as the obligee has some rational self-promoting purpose in his actions, then there will be no abuse of right, right? The leading case on this is Illinois Central Railroad Company. It's in the outline again. You know why we include cases, because it's the case or because the facts are recycled a lot. This is one of those cases where the facts are recycled a lot. In this case, there was a lease, and there was a clause in the lease that said that the lessee had to get consent from the landlord if the lessee wanted to assign or sublease the premises. Right? So if you want to assign or sublease, you have to get consent from the lessor. The property that was leased was a car dealership across the street from what is now the Superdome, right? This was like as the Superdome was being built, right? So as the Superdome is being built, right, the lessee wants to sublease the property to someone who's going to turn it into a parking lot, right? And that's going to make a lot more money. The sublease is going to be very valuable. The lessor refuses to consent to the sublease. The lessor says no way, right? Because the lessor is only entitled to the rent he's getting from his immediate tenant. And so his tenant is going to get this big windfall, and the lessor wants a piece of the action. So the lessor thinks if I don't consent, then eventually this lease will be breached, and then I can just directly lease to the parking lot people, right? Well, in this litigation, one of the claims that was raised by the tenant was abuse of right. My landlord is abusing the right to refuse to consent to the sublease, and they should be held liable for that. I should get to either sublease or I should get damages. And the court said, no, this is not an abuse of right. Right? Why? Because the landlord had a legitimate business purpose in refusing to consent. The landlord wasn't refusing to consent simply to cause harm or aggravation or out of spite to the lessee. The landlord was doing it to make more money, right? Which is the whole point of engaging in the lease to begin with, right? So no abuse of right in those circumstances. All right, so again, this fact pattern is occasionally recycled on the bar exam, or some variation of it is recycled in the bar exam, so be aware of that. And again, our new examiner, does reuse old questions. I mean, he kind of tinkers with the facts a little bit to make it look like it's a new question. It's usually an old question, right? So, be ready for that. All right, and again, the final note on abuse of right, it is an exceptional doctrine, again, right? So, which means it rarely wins. That doesn't mean you shouldn't raise it, right? If you see facts that implicate it, talk about it, but then say, this is an exceptional doctrine, it rarely wins, right? So, recognize that it may not prevail. All right, now if you look at the bottom of your handout, I've restated this case for you as a hypothetical because it's that important. This should be straightforward now. The lessor leases to the lessee, requires consent to sublease. The lessee wants to sublease the property, and the lessor says no way, right? Because he wants to renegotiate for a higher rent. Is this an abuse of right? No, not an abusive right, right? Why? Because the obligee did not exercise the right with the primary intention of harming the obligor. All right, we good? All right, the bottom of page 1, letter F, natural obligations. Guys, there is really no counterpart to this at common law. And so for this exact reason, it is tested fairly often, right? The natural obligation is a great way to weed out the common law folk, right, who haven't been trained in the Louisiana civil law. You need to know the law of natural obligations fairly well, right? So study this information, don't skip this. All right, so what is the definition? Well, there's not a great definition of a natural obligation in the code, right? And you might have talked about that in law school. Natural obligations aren't really legal obligations. They're not really civil obligations, to use another term. Instead, they are moral obligations, and the big idea here, guys, is that unlike civil obligations, these natural obligations are generally not enforceable by judicial action. So they're an obligation that exists, but they're generally not enforceable by judicial action. All right, so natural obligations can be difficult. It's really important to know exactly what the code says about them and then be able to kind of regurgitate that information on the bar exam. And we have the language that is relevant here for you in the Barbary outline. So rather than providing a definition, the code talks about when natural obligations exist, right? And it provides for their effects. So let's talk about that. First, when do natural obligations exist? The code says a natural obligation exists when the law implies a particular moral duty to render a performance. When the law implies a particular moral duty to render a performance. That goes in the handout. All right, so when does this occur? When does the law imply a particular moral duty to render a performance? If you look at the top of page 2 under examples, you're going to see that the Civil Code sets forth a list of potential circumstances in which a natural obligation exists. So these are circumstances, right, in which a natural obligation exists because the law implies a moral duty. There are at least 4 situations here. The first is a prescribed debt. See how that might come up, right? You've already talked about how this debt is prescribed, and then, oh, wait, there's a natural obligation that exists. Once a debt prescribes, even though the obligee can no longer sue to enforce the debt, right, to get payment, a moral duty exists. The obligor is morally bound to pay, even though the debt has prescribed. Now, there are other examples here, too, in the code. A debt discharged in bankruptcy. Even though the debt is discharged in bankruptcy, the obligor has a moral duty to pay. An obligation incurred by a person who lacks capacity. Sometimes a moral obligation exists. And even when a donation is invalid for lack of form, right, a moral obligation can exist. Now, the key here, guys, is that this list in the code is illustrative, and there are other circumstances that have been recognized by the courts in which natural obligations exist. Some of the big examples are here in your detailed outline. You should look through those, right? But I think the code examples are probably the ones you need to be most familiar with. Okay, so a natural obligation exists when the law implies a particular moral duty to render a performance, and we've talked about what that means. Now, what about the effects? Okay, so I mentioned to you that a natural obligation is not enforceable, that's what goes in the handout, not enforceable by judicial action. So the obligee can't sue to collect the prescribed debt, right? It's not enforceable. But the obligor still owes a duty, this moral duty. So there's got to be some effect here, something going on, right? So what are these effects? There are really 2. Okay, first, if he has performed, right, if the obligor performs, then even though the obligee has no right to compel performance, the obligor can't reclaim a performance that is freely rendered. Right? You can't reclaim a performance that is freely rendered. We're going to do a hypo on this in a minute to illustrate this. Now, this no reclamation rule, guys, is applicable whether or not the obligor knew that it was a natural obligation, right? If you freely perform, as long as you're not under duress, right, then you cannot get your performance back. In the jurisprudence on natural obligations, obligors will render a performance, right, that is no longer legally due. And then they'll later invoke the civilian principle of payment of a thing not due, right? They'll say, oh, I didn't know that because I wasn't legally bound to perform. And courts will say no, right? You freely performed according to a natural obligation, and so you can't reclaim your performance. All right, third, If the obligor makes a new promise to perform, then the code says that this new promise is onerous, right? The new contract to perform a natural obligation is onerous. We're going to talk about onerous cause a little bit more tomorrow, right? But another way of thinking about this from a common law perspective, if you're common law trained, is that the new promise to perform the pre-existing natural obligation is supported by consideration. Now watch out, because we're going to talk about this a lot. You're not going to say consideration ever on this exam, right? Because there's no doctrine of consideration in Louisiana. I'm just trying to give you an idea of how to understand what's happening with the promise to perform. But it's not a gift when you promise to perform a natural obligation. It's an onerous contract, right? And that has important consequences. All right, anyway, a promise to perform a natural obligation is enforceable as long, guys, as it is clear and unequivocal, right? Clear and unequivocal promise to perform, then we have an enforceable promise. Now, you'll recall, guys, and I've said this before, I told you I'd say it a bunch of times today, a promise to perform a prescribed debt must be in writing. So generally, a promise to perform a natural obligation doesn't have to be in writing, but the specific kind of duty, right, the promise to perform a prescribed debt, right? That always has to be in writing, always. That's the big exception. All right, here's the hypothetical. This is the example that comes up on the bar exam over and over again, right? Jack gives Jill a promissory note for $100, right? He fails to pay the note for 5 years, right? And let's not worry too much about the counting. Let's say prescription has run, right? Prescription is run, and after prescription is run, on this debt, Jack makes a payment of $5. Now, the question asks, is Jack now bound for the entire debt? No, right? No, Jack is not bound, right? He hasn't renounced prescription because there's no writing, right? But he has freely performed by making a partial payment, and he cannot reclaim that $5. Right, so no, Jack is not bound for the entire debt, but he can't freely reclaim the $5 because a natural obligation existed, right, that bound him to pay. All right, not bound for the whole, but can't reclaim the 5. All right, so that's natural obligations. Again, you'll probably be called upon to talk about that in some fashion. At the bottom of page 2, kinds of obligations. We're going to talk here about classifications of obligations. And guys, this is very important. It can seem kind of rote and silly, but in fact, this is a very civilian thing that we're doing here, a very Louisiana-specific thing that we're doing. You're going to see certain kinds of obligations on the bar exam, certain kinds of contracts, and you're going to need to state the classification of the obligation and then the effects that flow from that, right? If you're Louisiana trained, you certainly did this in your law school courses. I can also see these categories being tested in multiple choice questions, right? Really great fodder for multiple choice questions. Now, we have a number of different categories or classifications of obligations here we need to go through. The first one is real rights and real obligations. Of all of the ones we're going to talk about today, right, probably this is the least important because it's overlapping with property, right? And so it's not easy to tease out the distinction between the Code 1 and the Code 3 exam with this material, but we will cover a couple of the highlights that are important, right? So you may remember that real rights and obligations always deal with property rights, right? And in the civil law, we have this kind of deep distinction between real relations and personal relations or obligations, right? So a real right is defined at the top of page 3. It's a right in a thing that is good against the world, right? A real right is a right in a thing that is good against the world. It's not a right against a person to compel a performance, so it's a right in a thing. Now, the duty side of that is the real obligation, right? And this is kind of weird because it's really more related to property than obligations, has the word obligation in it. Anyway, think of it like a real duty. A real obligation or a real duty is an obligation incurred as a result of a real right. Again, for the handout, a real obligation is an obligation incurred as a result of a real right. All right, here's an example, right? Assume you have a predial servitude. Right, you'll remember from your coverage of Code 1 that a predial servitude is a charge on a servient estate on behalf of a dominant estate, right? Charge on a servient estate on behalf of a dominant estate. And the owner of the dominant estate has a real right to exercise the servitude, right? And the owner of the servient estate has a real duty or a real obligation, right, to refrain from interfering with the servitude, right? This is all property concepts. The important thing to know is that the obligation, the real obligation, right, is not owed by the owner of the servient estate in his personal capacity, right? It's owed by him in his capacity, his status as owner of the servient estate, right? So this real obligation follows the property and not the person. Now, this example gives you an idea of the effects of the real obligation, and this is what appears in number 3 on page 3 of the outline. Right, so first, a real obligation is transferred to the person who acquires the property without any agreement as to that effect, right? Anybody who acquires the property that is burdened with a real obligation is bound by that obligation, even if they don't consent to that. Right, that's what makes this different from a personal obligation. Right? Personal obligations don't follow the property, real obligations do. So when the owner of the servient estate purchased that property, he became bound by that servitude, even if he didn't consent to be bound by that servitude, right? Now, second, the owner of the servient estate, the obligor of a real obligation, right, is not personally bound. I said that before. He can free himself of the obligation by transferring ownership to someone else. Right? All he has to do is transfer ownership to someone else, either through a sale or a donation, or by abandoning the thing. Right? Free yourself of the obligation by freeing yourself of the thing. The obligation follows the property and not the person. All right, and this, of course, is different from a personal obligation. Right? And a personal obligation or a contract follows the person and not necessarily the property. So if I buy a house and I owe the seller the price, and then I sell the house, I still owe the seller the price, right? The obligation to pay the price doesn't follow the property around, right? Now, parties can transfer personal obligations, and we'll talk a little bit more about that later today. But absent a contract transferring those obligations, right, personal obligations stay with the person. Real obligations go with the property. All right, the next category that we need to cover is strictly personal and heritable obligations. Guys, this is far more likely to come up than the personal real distinction. This is one that is tested quite frequently on the bar exam. And the idea here, guys, is that we are deciding whether an obligation is enforceable only between the parties themselves, the parties that created the obligation, or whether someone else can either step into the place of obligor or obligee, right? Can we transfer our personal obligation to another obligor or another obligee? And you'll recall from law school, guys, the default rule here is heritability, right? The default is that obligations are heritable. And obligations are heritable when someone can step into the shoes of either the obligor or the obligee. The law favors transfer of obligations. And you'll also remember, guys, that even though we use the word heritable here, the code says heritable, a better word would probably be transferable, right? Because obligations can be transferred not only at death, right, through inheritance, but also, and what is more likely to come up on the Code 3 exam, in lifetime transactions of assumption and subrogation, which we're going to cover a little bit more later today, right? So transferability or heritability is the default term. Now, again, you're going to want to use that term heritable on the bar exam because, again, that's the terminology in the code. That's the terminology the bar examiners are going to be looking for. All right, so the default is heritability, but there are some exceptions, right? That is, circumstances in which an obligation is not heritable. And when an obligation is not heritable, we say that it is strictly personal. Right? If an obligation is not heritable, it is strictly personal. And when an obligation is strictly personal, then no one can step into the party's shoes. Right? Now, the determination of whether an obligation is heritable or strictly personal is, as I said, tested pretty often. And the answer depends on whether you're looking at the perspective of the obligee or the obligor. In other words, there are two different tests, whether we're trying to transfer the rights of the obligee or the duty of the obligor. So the first thing to figure out is who's trying to transfer their right or duty, right? Is it the obligee or the obligor? So let's talk about the obligor first. An obligation is strictly personal for the obligor when the performance requires some special skill or qualification or is a contract to perform personal services. Only the obligor can do it. The obligor can't transfer the duty to anyone else. I'll say it again. An obligation is strictly personal for the obligor when the performance requires some special skill or qualification of the obligor or is a contract to perform personal services, right? So think, for example, the obligor is a famous artist required to paint a portrait or something, right? No one else can do this for the obligee. The obligee wanted that person with those qualifications to do that job. Another example that came up in 2004, this is an exam that's no longer in your testing volume. The obligor said, if the Saints go to the Super Bowl, this is before the Saints went to the Super Bowl, if the Saints go to the Super Bowl, I will take you to the game and personally carry you on my back into the stadium. Right? If the Saints go to the Super Bowl, I will carry you into the stadium on my back. Then the obligor tried to transfer that duty to someone else. And the question came up, is this a transferable or heritable obligation? And the answer is probably no, because the contract probably contemplated a personal service, right? This is debatable. You could argue both ways, right? But probably no. Now, from the obligee's perspective, an obligation is strictly personal when the performance is for the obligee's personal benefit. That's the term of art, or the terms of art, personal benefit, the obligee's personal benefit. And this can be kind of hard to identify. Again, you can usually argue fact patterns both ways on this. There's an example in the Civil Code comments that also appears in your materials and has appeared on the bar exam a couple of times. This was a contract for ballet dancing lessons, right? So this woman was supposed to take dancing lessons and then she died. So she was the obligee. She had the right to the dancing lessons and then she died. Can her heirs take the dancing lessons? Do they get the right to the dancing lessons? Probably not. The court said in that case the lessons were for the exclusive benefit, you know, and personal aesthetic enjoyment, right, of the old lady who died. Personal benefit of the obligee. So that was a strictly personal obligation, and the right cannot be transferred. All right, so again, guys, remember the default rule is heritability. You always want to start with that statement, right? There are exceptions. It depends on whether you're looking at the perspective of the obligor or the obligee. You have the test, you have the language from the code. It's a good place to argue both sides of the coin, right? Where the examiner would like you to say, well, it could be this or it could be that, right? All right, the next thing in the outline is conditional obligations. These are often tested. You need to know this material pretty well. And you'll remember this can be a little bit tricky, but it's not too bad. All right, so a conditional obligation is an obligation that depends on an uncertain event. That's what goes in the handout, an uncertain event. Obligation depends on an uncertain event. Now, the key here, guys, is to know what we mean by uncertain, right? Uncertain event. An event is uncertain when we are not sure whether it will occur or not, right? We are not sure whether this thing will ever occur. In the example that I just gave you about the Saints going to the Super Bowl, right? We are uncertain about whether the Saints will ever go to the Super Bowl again, right? We are uncertain. It may never happen again, right? And so that's a conditional obligation that those parties entered into, right? Now, if the uncertainty is not about whether an event will occur, but when it will occur, we don't have a condition. We have a term, right? So for example, if I say, I'll give you my ring when I die, that's not a conditional obligation, right? That's an obligation subject to a term. There's a time period on it. And I don't make it conditional just by saying if. Right? If I said, I'll give you this ring if I die, that's still not conditional. I'm going to die. We might not know when, but eventually, right, everyone dies. So watch out for that. Uncertainty is key. We have to be uncertain about whether an event will ever occur in order to have a condition. If we're only uncertain about time, then we have a term. Now, I can make certain events, right, events that are bounded by time, uncertain by adding more sort of parameters to them. So for example, I could say, I'll give you this ring if I die before the end of the year. Now I've made a condition, right? Because we don't know whether I'll die before the end of the year. So it's truly an uncertain event. Now you'll recall that conditions can either be suspensive or resolutory in Louisiana. Suspensive or resolutory, those are the terms you need to know. Now, if you're common law trained, a suspensive condition is like a condition precedent, right? And a resolutory condition is like a condition subsequent. Don't use that language on the bar exam, right? You're going to want to use suspensive and resolutory conditions. And these are always tested on the bar exam, but probably the more frequently tested is the suspensive condition. So we're going to focus on that for a moment. When an obligation has a suspensive condition, the parties agree that the obligation isn't enforceable unless and until the event occurs, right? So unless and until the event occurs. So we don't know whether this event is going to occur. It's uncertain. So the obligation may or may not ever be due, right? We have no idea. Now, the very existence of the duty, guys, is dependent upon this uncertain event. The parties can still have a contract in the interim. They're bound in some way, but nobody has to perform, right, unless and until the conditional event occurs. Now, the resolutory condition is a little bit different. Here, if the obligation is subject to a resolutory condition, performance is due immediately, but the occurrence of the uncertain event extinguishes the obligation, right? So performance is due immediately, but the occurrence of the event retroactively extinguishes the obligation. So for example, if I sell you my house today, but we provide that should I ever become homeless, the house reverts to me, that's a resolutory condition, right? So the contract is immediately enforceable. In this suspensive condition, whether or not I ever become homeless, uncertain event, we don't know if it occurs. If it occurs, the sale is undone or unwound, right? Resolutory. All right, now, we have the two kinds of conditions. You need to be able to identify them on the bar exam. There's also something else we need to talk about here, and that's how conditions occur, how they come up. So first, conditions can come up naturally, right? In other words, the uncertain event can be something that occurs in nature. If I say, for example, I will cut your grass if it does not rain tomorrow, right? Whether or not it rains tomorrow, that's a natural thing. I have no control over whether it rains tomorrow. You have no control over whether it rains tomorrow, right? Natural or sometimes casual conditions you might have heard in law school. Now, other conditions are partly, at least, if not entirely, in the party's control or within the party's control. For example, I could say, I'll buy your house if I'm approved for financing, right? I'll buy your house if I'm approved for financing. That's partially in my control and partially not, right? I mean, I'm going to have to apply for financing. I have to do something, but the bank ultimately is going to make that decision, right? And so that condition could be out of my hands or in my hands. Now, the reason why we talk about conditions that are natural, conditions that are within the party's power, is because there are certain kinds of conditions, and these are conditions that are totally and completely within a party's control, right, that we're concerned about. These kinds of conditions render an obligation entirely null and unenforceable, right? So we have to watch out for these conditions that are totally and completely in the party's control. Now look, not all conditions that are totally and completely in a party's control are bad. Only certain ones. So we have to drill down on this and look at some vocabulary. There's some important vocabulary you're going to be called upon to use in the bar exam to describe what's going on here. All right, so first, when a condition is totally and completely in the party's control, this condition is called potestative or potestative. Your law professor might have used different sort of inflection there. Potestative or potestative. Common law people, this is like an illusory promise, a potestative or potestative condition. So when a condition is entirely within my control, it's potestative. Now the code makes an even finer distinction here between two kinds of potestative conditions. So some conditions are based on the will of a party, and other conditions are based on the whim of a party. So we have a will and whim distinction here. Now, this is the rule that you need to know, guys. Only conditions that are subject to an obligor's whim are null. I'm going to say it again. The only conditions that are null are conditions that are subject to an obligor's whim. And again, it's not just the condition that's null. The entire obligation is null. Okay, so let's talk a little bit more about what this whim thing is. Again, to use some important vocabulary here, we call these purely potestative or purely potestative conditions, right? Purely potestative. All right, so how do we tell the difference between whim and will? Again, guys, the code draws a very thin line here. Whim is defined, write this down, whim is defined as the obligor's unbridled discretion or arbitrariness. Unbridled discretion or arbitrariness. That's the language you want to use on the bar exam. If you see a condition that is within a party's power to fulfill or not, you need to recognize that if the condition is based on the obligor's whim, that is within the obligor's complete discretion or arbitrariness, then the entire obligation is null, right? Now, what is unbridled discretion or arbitrariness? I mean, it's basically the legal equivalent of the obligor saying, I'll perform if I feel like it, right? If I feel like it, I'll perform. Right. Now the trick here, guys, is that in real life this almost never happens, right? There's always, usually, some reasoned thought process that goes into an obligor deciding whether or not to perform. There's some benefit the obligor would forego, right, if he did not perform. And just that, right, makes the obligation subject to a condition that's based on will rather than whim. But you still have to go through the motions of discussing all of this on the bar exam to get all of your points. All right, so here's the hypothetical that could come up on the bar exam. So let's say, this is in your handout. Jill agrees to sell Jack her house in Baton Rouge. Agrees to sell her house to Jack in Baton Rouge if she decides to move to New Orleans. If I decide to move to New Orleans, I'll sell you my house, right? So is this contract enforceable? Well, yes, right? That's the final answer. How do we get there? Well, this is a contract subject to a condition. It's subject to a suspensive condition. It's subject to a potestative condition, right? Because whether or not Jill decides to move to New Orleans is within her power, right? And indeed, it's purely potestative because it's totally within her power to decide whether to move to New Orleans. The trick is deciding whether that condition is based on whim or will. To be based on whim, it would have to be subject to unbridled discretion or arbitrariness, right? But the decision to move to New Orleans is not based on unbridled discretion or arbitrariness. It's going to involve a lot of factors, a reasoned decision-making process. Can she afford to move to New Orleans? Can she get a job in New Orleans? Can she find another place to live in New Orleans? Can she get her kids into school in New Orleans, right? There are going to be a lot of factors there. That makes this condition subject to her will and not her whim. Therefore, the contract is enforceable. That's a lot to go through, right, to get to the answer, but you have to be prepared to do that on the exam. Now, if you look in your outline on page 5, you're going to see another example here from a relatively famous case, right? It's another way of thinking about how these rules play out. This is a case about a landowner. He sold a mineral royalty, and then the mineral royalty was extinguished for 10 years of non-use, right? So the buyer of the royalty tried to get his money back by saying that it was based on, the sale was based on a purely potestative condition, that is one based on whim, right? And the landowner, he argued, had the power to drill but chose not to, right? So it was within his discretion whether to drill, and that affected his rights. But the court said no, the landowner, the obligor's decision to drill or not, right, was based on a host of factors, right, like whether he wanted to enter into mineral leases and how it would affect, the surface of his property, etc. And so therefore the condition was based on will rather than whim. Right, so again, guys, it's just another example of courts going through that process of deciding whether a condition is based on whim or will. The upshot here, one thing you need to remember is that the condition you're going to be asked to evaluate is almost never subject to whim. It's almost never subject to whim. I mean, it's very difficult to find real cases in the jurisprudence where courts have said, yes, this is a condition based on whim. Now, a key here to remember is that if you have a resolutory condition, this is number 2 on page 5, if you have a resolutory condition, it doesn't come under the same nullity rule, excuse me. The doctrine, the jurisprudence says it's almost impossible for a resolutory condition to ever be based on whim, right? Because if you're undoing a contract, there's a reasoned thought process going into that. There are consequences people are thinking about. But all resolutory conditions, the code says, must be exercised in good faith. That's an important rule to remember. All resolutory conditions must be exercised in good faith. Now, there's nothing magical going on here. All obligations must be exercised in good faith, right? But the code is very specific here, that resolutory conditions must be exercised in good faith. So if I sell you my house, but I say I want it back if I feel like it, right? That's a resolutory condition. It's based on the will, right, of one of the parties. It has to be exercised in good faith. Yeah? Okay. Now let's talk about obligations with a term. When we talk about conditions, remember we said we always have uncertain events, right? But with terms, we know that an event is eventually going to occur. We may not know when, that's okay, but we know eventually the event will occur. So remember, I'll give you this ring when I die, right? That is an obligation subject to a term. Now, the important effect of a term is that terms are generally periods for the performance of an obligation. That's the definition in the handout that you need to know. A term is a period for the performance of an obligation. If there is no term for performance, the obligee can demand performance immediately, right? So the term is like a grace period for performance. Now, the first thing that you'll want to remember about terms is that there's a presumption that terms benefit the obligor. Right? We presume that terms are for the benefit of the obligor. The obligor is usually better off if he can wait before repaying or performing, muster resources, right? Gather capital, etc. So the obligor can generally waive or renounce a term, right? Because it's in his favor. He can choose to give it up, right? If I borrow $100 from you and you give me a year to repay, I can just repay early, right? I can waive or renounce the term. Now, the only time the obligor cannot waive or renounce the term on his own is if that is prohibited by the agreement or if the term actually benefits both parties. In both of those cases, the obligor and the obligee have to agree to modify the term in the contract, right? So you need to remember that rule. Now, the trickiest part about terms on the bar exam, I think, will be distinguishing between terms and conditions, which we've already talked about a little bit, right? The test is whether the event affecting the obligation is actually uncertain to occur, right? That's the idea. Now, there's a case cited in your materials at the bottom of page 5. That's an important case. It's a seminal case on this issue of distinguishing between terms and conditions. This case involved an agreement between a subcontractor and its workers on a big construction project. So we had a subcontractor who hired workers to do some construction work. The contract said the subcontractor would pay the workers when the subcontractor was paid. In other words, the boss said, when I get paid, I'll pay you, right? Pay when paid. That's the kind of clause in this contract. Now, what happened here is that the whole contract failed. The whole project failed. The owner went bankrupt. The general contractor never got paid, right? The subcontractor never got paid. And now the subcontractor doesn't want to pay his workers, right? And so a dispute arose over whether this agreement in the parties' contract was about time or whether the workers were ever entitled to be paid. If the contract was subject to a condition, then the workers would not be paid unless and until, right, the subcontractor got paid. But if this was merely a term, then eventually the workers get paid. This is just about when, right? Now, the court looked at this issue, and this is the important thing about this case. The court said distinguishing between a term and a contract is not about uncertainty in the abstract. It's about what the parties contemplated, right? So let's think about this for a minute. In fact, it is uncertain whether the subcontractor will ever get paid, right? We don't know if the subcontractor will ever get paid. So in the abstract, that was a conditional event. But the court looked at the facts and circumstances and said that when the parties made this contract, they contemplated that everybody was going to get paid eventually, right? Nobody agreed to work for no pay, potentially, right? And so the parties had in their agreement understanding contracted for time, right? And not for the potential that they would not get paid. And the court therefore said that this was a term, even though in fact, in the abstract, it's uncertain whether these people get paid. Based on the relative understanding of the parties, this was a term, right? So whether we're dealing with a term or a condition is relative. Now also you'll recall this rule about terms, because the time for performance wasn't fixed in the contract, right? It didn't say when exactly the workers were going to get paid. The court said that the sub had a reasonable time to pay, right? When we don't fix time precisely for a term, the court supplies a reasonable time, right? It's another important rule about terms you need to remember. All right, this hypothetical, I know it's long, but it's important, right? And so I put it in your outline and your handout so that you can remember the gist here. The sub tells the worker, I'll pay you when I'm paid, and then never gets paid, right? This looks like a condition, but because the intention of the parties was that the agreement was as to timing only, right, this is a term. So the sub is bound to pay the workers eventually, even if he never gets paid. And because the term is undetermined, the sub has a reasonable time to pay the workers, a reasonable time. All right, if you have questions about that hypothetical or that case, you can email me anytime and I'll chat with you about it more. All right, next up, obligations with multiple persons. All right, so this is tested relatively frequently, and we're going to need to review this in some detail. You're going to remember, guys, this is the solidary obligation stuff. This is the worst part of what we're going to be doing today. It's pretty difficult. Let's back up for a moment and think about what it is we're talking about when we say obligations involving multiple persons, right? Technically, all obligations involve multiple persons, right? Because you always have at least one obligee and one obligor. That's not what we're talking about. With obligations with multiple persons, we're talking about multiple obligees or multiple obligors, right? So we're going to have more than one person on at least one side of the obligation. Now, there are three possible scenarios here. If you have multiple persons on one side of the obligation, we can have several obligations, joint obligations, or solidary obligations. Those are the three options. And now look, for each of these types of obligations, you can have effects as to obligees or obligors. In other words, I could have several obligees, joint obligees, solidary obligees, or I could have several obligors, joint obligors, solidary obligors, right? In real life and on the bar exam, we're concerned about obligors, right? The obligors rules are the ones that always get tested. And that's what all the code articles are about anyway, right? So we're going to focus on obligors in this lecture. All right, first, let's talk about several obligations. Several obligations exist when multiple obligors owe separate performances. We have multiple obligors, they owe entirely separate performances. And the big idea here, guys, is that each obligor only owes his own performance, right? Separate performances, each obligor only owes his own performance. This is best explained with an example, right? Don't overthink this. This is in your handout. Let's say that Jack is a cabinet installer, right? And Jill does flooring work, right? So they're both, you know, home repair kind of people. Sometimes these two people work together on jobs, right? They team up and do things at the same time, right? And so in a single contract, a single piece of paper, right, with the owner, Jack agrees that he will install cabinets at the owner's house, and Jill agrees that she will refinish the floors. In this instance, guys, Jack and Jill are severally bound, right? They're severally bound. Each has promised an entirely different performance, right? Jack has only made promises about the cabinets. Jill has only made promises about the floors. The fact that they made their promises on the same piece of paper is entirely legally irrelevant, right? It says they could have executed two totally separate contracts and the same effects would have flowed from this agreement. So separate performances are owed. This contract produces the same effects as if Jack and Jill had entered into separate agreements with the owner. We treat this just like individual obligations, right? So straightforward, it's almost confusing in its straightforwardness, right? Now, joint obligations, getting a little more complex here. Joint obligations exist when multiple obligors owe a single performance. So multiple obligors owe a single performance, but they promise they will render it collectively. I'll say it again. Single performance, they promise they will render it collectively. And the idea here, guys, when we have a joint obligation, is that each obligor only owes his share or part of the obligation, right? We divide up the obligation, and each obligor is liable only for his part. Again, I think an example is helpful here. Let's say that Jack and Jill decide to go into business together, right? Finally. And they borrow money from the bank to finance their venture. Jack and Jill sign a note in which they promise collectively to repay the amount borrowed. They borrow $100,000. They sign a note in which they agree to collectively repay the $100,000. Based on these facts, Jack and Jill are jointly bound, right? They're jointly bound. They've promised a single performance they're going to perform collectively, right? But the key here, guys, is that each only owes their part. Jack owes 50, Jill owes 50. They can each only be called upon to pay half, right? All right, finally, solidary obligors. These are obligations in which we have multiple obligors. They owe a single performance, right? Like a joint obligation, a single performance. But here, this is the kicker, they're all bound for the whole. Each one of the obligors is legally bound for the whole. So you have a single performance, each person is bound for the whole. Now the obligors may bind themselves this way specifically. They might say, we are solidarily bound, or we are bound in solido, right? Or something like that. You can do that expressly, but they don't have to say that. It could be more subtle than that, right? They could sign a promissory note, and the promissory note can say, I promise to pay the sum below, and then we can have multiple people sign that note, right? Without any language indicating that the parties are going to divide up the amount due, that's a solidary obligation. There's clear case law to that effect, right? Now, the key here again, guys, is that when you have a solidary obligation, each obligor can be compelled to pay the whole thing, right? Again, let's do an example. Let's say that Jack and Jill go into business together. They borrow the money from the bank. It's $100,000. They sign a note that says, I promise to pay the amount below. They each sign it. The note does not explicitly say that the parties are solidarily bound. Nonetheless, because of the language in the note, Jack and Jill are solidarily bound, right? Jack and Jill are solidarily bound. That means that the bank can ask Jack to pay $100,000, or the bank can ask Jill to pay $100,000, right? Now, of course, the bank can't get double recovery, right? But the bank could ask either of the parties to pay the full amount. Now, this example should remind you that solidarity is often the result of a contractual undertaking, right? The parties agree to be solidarily bound, right? But the law supplies solidarity in many circumstances, right? This comes up occasionally in the law of torts, for example, right? So you see situations in which employer and employee are solidarily liable for an employee's negligent acts, right? In some cases, we're going to see solidarity come up in sales law from time to time. The law simply says these parties are solidarily bound in these circumstances, right? So whether the parties agree to that or not, the law will say they're solidarily bound. All right, so one more thing that's important here, guys, before we get into some hypotheticals and examples. If you look at the bottom of page 6, the very last thing here, letter C under 3, joint obligations treated as solidary. The effects of joint obligations, right? That is, when we say that each obligor only owes his share or part of a joint obligation, that's only possible sometimes, right? That's only possible if an obligation is, as we say, divisible, right? The obligation has to be capable of being divided into shares in order for the obligors to be treated as joint obligors. If an obligation is indivisible, we are required to treat the obligation as solidary, right? So again, even if an obligation looks like a joint obligation, if the obligation is indivisible, we apply the law of solidary obligations to that obligation. All right, so again, for the handout, when is a joint obligation treated as solidary? When the object of the obligation is indivisible. All right, here's an example. Jack and Jill are joint obligors on that promissory note, right? Now, look, paying money is generally by itself a divisible obligation. You can divide up the dollars, right? Jack could pay 50 and Jill could pay 50 physically, right? It's divisible. Money is fungible. On the other hand, if Jack and Jill promise to paint my house, right? Well, now we have an indivisible object, right? An indivisible performance, right? There's one single performance. It's not really something that can be divided up, at least not in the normal course of events. Because they have to collectively render that performance and we cannot divide it up, we're going to treat that obligation as solidary, even if it would otherwise technically be a joint obligation, even if they express no intent, for example, to be solidarily bound. We'll treat it as solidary. The other thing to remember, and I'll remind you of this in a moment, what's far more likely to come up on the bar exam, is that parties can make obligations that are divisible by their nature, indivisible by agreement. This happens all the time in loan documents, right? Remember that obligation to pay money, that can be divided up, that can be divisible, but often the loan document itself will state that the loan is indivisible. Right? And once we do that, now we have to treat the thing like a solidary obligation, right? Because the parties have opted into that indivisibility. All right, now the most important thing to know about solidarity on the exam is its effects. So the primary effect of solidarity we've already talked about a little bit, and that's that the obligor, each obligor owes the entire performance, the whole performance. The obligee can look to any one of the obligors and get paid back in full, right? Now, solidarity of obligors, guys, is for the benefit of the obligee. It makes the obligee's life easier, right? When Jack and Jill borrow that money from the bank wants Jack and Jill to be solidarily bound because it makes it easier for the bank to recover the whole debt, right? The bank can look to whoever is the easiest to sue, the one with the deeper pockets, the one with more cash on hand, right, to recover the debt. Now, because solidarity of obligors is for the benefit of the obligee, there are a couple of things that the obligee can do that affect solidarity, right, that sort of mess with it. And we have these things spelled out in the outline. All right, so these are renunciation and remission. Renunciation and remission. All right, so first, the obligee can renounce or waive solidarity. Either renounce or waive solidarity. Make solidarity essentially go away. Second, the obligee can remit the debt as to one or more of the obligors. I'm going to go into a lot of detail on each of these. So let's take renunciation first. All right, so the obligee certainly can renounce solidarity if he wants to, right? The bank gets Jack and Jill to agree that their debt is solidary, and then later the bank can say, oh, never mind, the bank isn't solidary. I renounce solidarity. Fine, the bank can do that. The only requirement of a renunciation of solidarity is that it must be express. That's important. It has to be express. We're not going to infer this from facts and circumstances. Don't require a specific form. It doesn't have to be in writing or anything, but it has to be express. If the obligee renounces solidarity as to all of the obligors, right? Now they don't each owe the entire debt anymore, but we divide the debt up between them. It's like they've become joint obligors, right? What happens more frequently on the bar exam, right, is that the obligee renounces solidarity as to less than all of the obligors, right? We have renunciation of solidarity as to less than all of the obligors. All right, so let's do a hypothetical that's in your handout. This is a little more difficult because I've added some obligors. Let's say we have a debt for $100,000 and we have 4 obligors. The obligee renounces solidarity as to one of them, right? What happens now? Okay, so as the one for whom solidarity has been renounced, the obligee can only get his share, right? It's like we're treating that person, just that person, like a joint obligor. He'll owe 1/4 of the debt, or here $25,000. $25,000, 1/4 of $100,000. Now, what about the other obligors, right? The ones for whom solidarity was not renounced. They're still solidary, right? They're still on the hook for the whole, but it's not the original whole. It's not the entire $100,000. It's the whole minus the renounced share, right? So now the whole debt was $100,000. The obligor renounced essentially one $25,000 share. And so now we have $75,000 that can be collected from the remaining 3 solidary obligors, right? So that's what you want to write in the answer to the hypothetical, right? The bank can collect 1/4 of the debt, or $25,000 from A, and the bank can collect the remaining portion, or $75,000 from C, right? Write that down. If you have trouble with that when you're going back over it, just email me. I'm happy to chat with you about it more. All right, that's renunciation, when we're essentially making an obligation that was solidary joint as to all or less than all of the obligors. Now let's talk about remission. Remission is different, right? Remission is releasing an obligor from the debt entirely, right? Releasing an obligor from the debt entirely. Now, an obligee might do this for free, gratuitously, out of the goodness of his heart, or the obligee might do it as part of a compromise, right? Either way, we are releasing an obligor from the debt entirely. Now, unlike a renunciation of solidarity, a remission can be express or tacit. Write that down, express or tacit. The code even sets out a presumption for one type of tacit remission. If the obligee surrenders the instrument that evidences the debt, right? That's a tacit remission, right? So if I have a promissory note, you're bound to pay, and I give up the promissory note, that's a tacit remission. Why else would I give away the only proof I have that you owe me debt if I didn't mean to forgive the debt, right? It's a presumption. It's not deemed, but it's a presumption. All right, now remission goes beyond mere renunciation, because again, the remitted obligor is totally off the hook. They don't have to pay anymore. It's a complete release of that debtor. The debtor who's remitted owes nothing, right, to anyone. So what does this mean for the rest of the obligors who are still solidarily bound? This is the next hypothetical in your handout, right? Let's work through this one together. Again, same deal. We have 4 debtors. They owe $100,000. They're solidarily bound. One of them, A, is remitted, right? When A is remitted, he now owes nothing. He owes nothing, $0. But the obligee can still go against the remaining obligors, B, C, and D, for the whole debt minus the share of the remitted obligor, right? So again, the whole debt, $100,000, minus the share of one, $25,000. The bank can go against the remaining solidary obligors for $75,000. Again, the remaining obligors are bound for the original debt after deduction of the share of the remitted obligor. All right, so the answer you want to write in there, what can the bank collect from A? $0. What can the bank collect from C? $75,000. Right? If later you're working backwards from that and you get tripped up, just email me. All right, this is about to get worse. This has all been about the relationship between the obligors and the obligee. We have still to talk about the relationship of the obligors in solidarity. What rights do they have against one another? All right, so of course, a solidary obligor who pays the entire debt to the obligee or more than his share can sometimes go after the other solidary obligors for some repayment, right, to get some of that money back. And you'll recall from law school that this can happen in 2 different ways. There are 2 different things that can happen here: contribution and indemnity, right? Contribution and indemnity. Contribution is way more common on the bar exam, right? So it's what we're going to focus the most on. This happens when the obligation concerns all of the obligors, right, as opposed to only one or some of them, right? So whenever this is true, then although any of the obligors can be called upon to pay the whole debt to the obligee, after the obligor has paid the whole debt to the obligee, that obligor can seek contribution from the other solidary obligors, right? Can seek contribution. So what can you seek from the other obligors? Between each other, each of the obligors owes their virile share, their portion, right? Now in contract, unless the parties agree otherwise, we just divide the debt by the number of heads, right? Virile basically means by head, per man, by head, right? So in my example of A, B, C, and D and the $100,000 debt, right, their virile shares are a fourth each, or $25,000, right? We divide it up equally. All right, now we're going to do an easy example of contribution first. This one's in the outline and the handout. All right, so we have 4 obligors on a $120,000 note now. One pays the full amount to the obligee, right? The whole $120,000 to the obligee. Each of the remaining obligors is going to have to pay in contribution, right? Each obligor owes between each other $30,000, right? Or 1/4 of the $120,000 debt, right? So when A pays $120,000 to the bank, then he can collect 30 each from B, C, and D, right? Again, generally when an obligation concerns all of the obligors, right, like a debt like this one, when one pays more than his share, he can get contribution from the other obligors up to the amount of each obligor's virile share, right? Now that is actually relatively straightforward compared to what we're about to talk about, right? So you'll recall from law school that contribution gets much more difficult when one of the obligors becomes bankrupt, right, is insolvent. When we introduce insolvency into the equation, things become more difficult. So first let's look at the rule here. The outline restates the rule from the Civil Code, which is what you need to know, and that is that a loss arising from the insolvency of a solidary obligor must be borne by the other solidary obligors in proportion to their portion. That language is terrible, but you have to just memorize it, right? So let's say it again. A loss arising from the insolvency of a solidary obligor must be borne by the other solidary obligors in proportion to their portion, right? So when one solidary obligor becomes bankrupt or insolvent, the other solidary obligors have to pick it up in contribution, right? They're going to have to make up the difference, right? And this applies, guys, even when we have a solidary obligor in whose favor solidarity has been renounced. That's a super important exception, right? Even when we have an obligor in whose favor solidarity was previously renounced, if another solidary obligor becomes bankrupt, that solidary obligor is going to be called back in to pay his share of the insolvent obligor's share. That's tricky. All right, let's do an example of this. Again, this is in the handout, the outline. Let's assume again that A, B, C, and D borrow $120,000 from the bank. And let's assume that A pays $30,000. And solidarity is renounced in A's favor, right? So solidarity is renounced in A's favor. Now the bank collects the remaining 90 from C, right? The whole debt minus A's renounced share, $90,000 from C. And let's assume that B becomes insolvent. A lot going on here, right? So B is insolvent, B is unable to pay anybody anything. What can C collect? C can collect from D in contribution D's virile share, right, or $30,000. Also, right, in addition, because of the loss arising from insolvency, right, because C can't collect anything from B because B is insolvent, C can collect from D B's share, right, of, D's share of B's share, or a third of B's share. Said another way, right, A, C, and D all have to bear B's share, right? So when C seeks contribution from D, C gets not only D's original virile share, he gets a third of B's virile share from D, or 10. That means that the full amount that C can collect from D is $40,000, right? $40,000. Now, C can also collect something from A. Even though A was renounced, right? Remember, we call in previously renounced obligors to pay their share of the insolvent's share. So A is on the hook now for $10,000, right? So this is what I want you to write down in the handout as the answer. What can C collect from D? $40,000. The $30,000 virile share plus $10,000, D's share of B's share. What can C collect from A? $10,000, right? $10,000. Go back over that this afternoon, right? After you've had a chance to look over the material. If you have questions, just email me. I'm happy to go through it again with you. All right, one additional level of complexity, and then we will wrap it up. Now, you'll recall that the rule is a little bit different if one of the solidary obligors is not renounced, but instead is remitted, right? So this is what happens when a solidary obligor isn't renounced. A was previously renounced. Now we're going to say A was remitted. The rule here is that although normally a loss arising from insolvency has to be borne by the other solidary obligors, when an obligor has been remitted, he can't bear that loss. He's been entirely released from the debt. So what does the law say? This is important. The obligee bears that share. The obligee bears that share, right? The remitted debtor can't bear it, so the obligee bears that share. All right, let's do the example of this. Same facts, except for we have a remission. A, B, C, and D liable in solito to the bank for $120,000. Here, the bank remits A, totally releases him from the obligation. A is gone. B becomes insolvent. Now, what can C collect from D? Here, the answer is the same. Same answer for D. D owes his $30,000 virile share plus 10, his share of B's share. The difference, though, has to do with A. Because A has been remitted, A is off the hook completely. A cannot be brought in to bear a share of B's share, right? So A owes nothing, but the obligee, the bank, has to pick up a share of the insolvent obligor's share. So that means that technically what happens here is that the bank owes 10. Now, of course, right, in real life, we'd have a sort of compensation occurring and the bank would just collect less, right, from C. But it is not inappropriate to say, right, that the bank ends up owing 10 in contribution because of B's insolvency. So what do you need to write down here as the final answer? What can C collect from D? $40,000. $40,000, the $30,000 virile share plus 10, his share of B's share. What can C collect from A? $0. But what can C collect from the bank? 10, right? That 10 is owed by the obligee, the bank. All right, the last thing we need to talk about here, guys, and then we'll take a break, is indemnity. This will be quick. Remember, so far we've been talking about the obligor's rights against each other in contribution. On the other hand, when a debt only really concerns one of the obligors and the other obligors are acting as sureties, then when one of the obligors pays, he's entitled to indemnity, right? He's entitled to indemnity. A surety is entitled to full repayment, right? And not merely to the debt minus his virile share. So when we have suretyship or other obligations of that type, the arrangement is indemnity, and an obligor who is not the principal obligor who pays is entitled to full reimbursement. All right, we're going to take a break, and we'll come back and we'll finish off this outline. All right, guys, let's pick it back up. We'll finish off this outline on obligations today. As I said before, this should take us just a little shy of an hour. That's my aim. All right, so we finished obligations with multiple parties. We have finished solidary obligations, thank goodness, right? We'll move on now to conjunctive and alternative obligations. The good news here, guys, is that this material and the rest of the material in this outline is eminently easier than the solidary obligation stuff. We're through the thick of it. All right, so conjunctive and alternative obligations. Remember what we're doing here. We are still classifying obligations, right? We're identifying a type of obligation on the bar exam. We're stating what legal effects flow from that classification, right? So a conjunctive obligation exists when an obligor is required to render multiple items of performance, each of which must be separately rendered. I'll say that again. A conjunctive obligation exists when an obligor is required to render multiple objects of performance, multiple items, each of which must be separately rendered. The most common example of a conjunctive obligation, and where you might find yourself talking about this, is when a lessee, a tenant, owes a monthly rental on a lease, right? So the lessee has the ongoing duty to pay rent. It's due every month. This is a conjunctive duty, right? Because the lessee must render a performance each period. So let's do the hypothetical in the handout, right, that illustrates this point. Let's say that A leases property to B for a term of 5 years. The monthly rent is $1,000, right? The monthly rent obligation is a conjunctive obligation. Wouldn't hurt for you to say it on the exam. The significance of this obligation being conjunctive, one of the most important effects of the obligation being conjunctive, is that each payment is subject to its own liberative prescription. I said that earlier. The rationale for that separate prescriptive period is that the obligation is conjunctive. That's how we explain that rule. Again, this is tested on occasionally. The examiner may give you a 5-year lease, may tell you the first month's rent was never paid, right? So even if the lease is ongoing, right, the action to collect the first month's rent prescribes, right, after a certain amount of time, you count from the time each payment was due and not from the end of the entire lease. Why? Because the obligation to pay rent is conjunctive. Yeah? Okay. So that's really all we need to know about conjunctive obligations. We'll move on now to talk about alternative obligations. Alternative obligations also involve multiple performances, but the idea here is a little bit different. An alternative obligation is one in which the obligor is bound to render one of multiple items of performance. So the obligor doesn't have to render all of the performances, but only one or some of those performances. This has occasionally been tested on as well. There's actually a really great example of the alternative obligation in the law of lesion. It appears in your outline, but we haven't covered lesion yet. We're going to cover that on Wednesday, so we're going to skip that example for now. Require me to talk all about lesion for a while. We'll do that later. But there's another example in your handout, and this one is actually from an old exam. It's a question that used to get recycled every couple of years by the old examiner about a guy who buys a car, and he has the choice of the sedan or the coupe. Right? He has the choice of the sedan or the coupe. So this is an alternative obligation as well, because the obligor can either deliver the sedan or the coupe, but it's not going to be both of them, right? It's going to be one or the other. Another example that was used on the bar exam in the past, I think it was back in 2004, so it wouldn't appear in your testing volume anymore, had to do with a television station that signed a contract with an advertiser, right, saying it would get so many hours of advertising. And the advertising contract was split into percentages, either 60% television and 40% radio, or 80% television and 20% radio. In other words, we're going to advertise for you. We're either going to split this up 60-40 TV, radio, or 80-20 TV, radio. So the obligor didn't have to do both, right? It was one or the other. So whenever you see a contract like this that involves multiple performances and there's some option between which performance is to be rendered, you should identify this as an alternative obligation, right? Now there are 3 effects that flow from this classification that you want to keep your eye out for and be ready to talk about if it's relevant. All right, first, this is the most obvious one, only one of the performances has to be rendered, right? It's not both, not all, it's one or the other. And importantly, the default rule is that the obligor gets to choose unless the right is given to the obligee in the contract, right? So normally it's the obligor who gets to choose, but of course the parties can say the obligee gets to choose. All right, importantly, second, it's either one performance or the other, right? It's all of one performance or all of the other performance. It's either the sedan or the coupe. Right? It's either 60-40 TV radio or 80-20 TV radio, right? We can't suddenly come up with 50-50 TV radio. That wasn't one of the options, right? So it's one of the options, it's all of one of the options or all of the other. And finally, and this rule gets tested on occasionally, if one of the items of performance becomes physically impossible, then the other item of performance must be rendered. Right? If one of the items of performance becomes physically impossible, the other item of performance becomes physically impossible. For example, if you're supposed to choose between a sedan and the coupe, and the sedan gets struck by lightning and burns up, you got to take the coupe, right? You have to go with the other option. And the only way the obligor is let entirely off the hook is if all of the items of performance become impossible, right? All of the items of performance become impossible. Now we're going to talk about impossibility some more in a little while, right, before the end of the hour. So stay tuned for that. All right, the next issue we need to talk about, just for a tiny second, is divisible and indivisible obligations. We've really already covered this because the way that it comes up and the way that it's important is in the context of solidarity, and we've covered that already. We'll just talk about the definitions quickly again. For the handout, a divisible obligation is one in which the performance can be divided, right? When you can divide up the performance, divide up dollars, right? It's a divisible obligation. With an indivisible obligation, the performance cannot be divided, right? Now, the only thing I want to add here or remind you of is that indivisibility can be natural, can be because of the nature of the contract, or it can be effectuated by the consent or intent of the parties, right? So remember I gave you the example earlier of parties making a money debt indivisible. It's entirely possible to do. Although it is naturally possible to divide up money debts, the parties can agree that their debt is indivisible. And remember the effect of calling an obligation indivisible. We always treat it as solidary if there are multiple obligors, right? We treat it as solidary if there are multiple obligors. All right, that brings us to the end of classification of obligations, and we're going to move on now to talk about transfer of obligations. We've talked already about the classification of strictly personal and heritable obligations, right? And you'll recall that heritability or transferability is the default rule, right? So by default, we can transfer obligations. So this material talks about how we transfer obligations, right? How does that occur? Now the rules here differ depending on whether we're looking at this from the vantage point of the obligor or the obligee. That is, are we looking at the duty side of the obligation or the right side of the obligation? Assumption of an obligation transfers the obligation from the vantage point of the obligor. Assumption transfers duties. Subrogation transfers the obligation from the vantage point of the obligee. Subrogation transfers rights. We're going to talk about the details of each of these in a moment, but one point I want to make here at the outset that's really important to remember, like super important to remember, is that these two things don't always occur simultaneously, right? Just because you've transferred your duties through an assumption does not mean you've also transferred your rights through a subrogation, right? You have to do each independently. I mean, you can do it together in the same contract, but you have to follow the rules for each, right, independently. All right, so first let's talk about assumption. You can have an assumption that's an agreement between an obligor and a third person, that the third person will pay the debt or render the duty, right? So this is an agreement between the obligor and a third person, right? Here's an example. Let's say that Jack sells a house to me on a credit sale, right? So he sells the house to me, I owe the price. Before I pay off my debt to Jack, I sell the house to Jill, and Jill assumes my debt to Jack, right? Remember, because this is a personal obligation, she's going to have to assume the debt to be bound. It's not a real obligation. It doesn't follow the house. She has to assume it, right? She assumes my debt to Jack. So this is an assumption between a third person, Jill, and me, the original obligor, right? Jill has agreed with me to pay the debt. This type of assumption between an obligor and a third person need not be in writing to be enforceable between the third person and the obligor. Doesn't have to be in writing to be enforceable between the third person and the obligor. But, big exception here, a big but, to be enforceable between the obligee and the third person, it has to be in writing. I'm going to say that again. It's important, tested quite frequently, in fact. Last on the July 2014 exam. You'll see this in a question about leases. An assumption between the obligor and a third person need not be in writing to be enforceable between the obligor and the third person, but it must be in writing to be enforceable between the obligee and the third person. Right? So we're going to need a writing for that enforceability by the obligee. So here's the hypo in your handout. Again, this is adapted from that 2014 bar exam question. Jack sells his house to Jill on credit. Before Jill pays the price, Jill sells the house to Joe. Jill and Joe verbally agree that Joe is going to assume Jill's debt to Jack, right, and pay him directly. So the hypothetical asks you, can Jack sue Joe to enforce this agreement? Can Jill sue Joe to enforce this agreement? Who can sue Joe, essentially, right? Well, this is an assumption between the obligor, Jill, and a third party, Joe, right? So the agreement between Jill and Joe need not be in writing. Jill can sue Joe without a writing. That's fine, provided she can prove the existence of the contract. But in order for the debt to be enforceable by a third party, right, in order for Jack to sue Joe, we would need a writing, and we don't have one. And so Joe cannot be sued by Jack directly, right? Instead, Jack's going to have to sue Jill for the price, and then Jill will sue Joe. Got it? All right, second, we can have an assumption that's an agreement between the obligee and a third person, right? So the obligee can agree with a third person that a third person will pay the debt, right? This is less frequent when this occurs, but it can occur. The important thing to know about this rule, or this kind of assumption, is that it always has to be in writing. Whenever there is an assumption between the obligee and a third person, it always has to be in writing. If the agreement in my hypothetical that I just gave you were between Jack and Joe, if they had entered into the contract, then to be enforceable by anyone, it has to be in writing, right? That's an important rule to remember. Now, besides the writing requirement, the most important thing to remember about an assumption, the most important thing to remember about an assumption, no matter how it arises, is that it does not release the original obligor from the debt. It does not release the original obligor from the debt. We call this a transfer, but we're really just adding people, right? You'll remember that from law school, right? So the other kicker here is that the obligors are now solidarily bound. Oh, that's where we're going to have to talk about solidarity, right? We're going to have an assumption. We're going to have a new obligor. They're solidarily bound. What are the consequences of that, right? You can see that playing out in a bar exam question really easily. All right, that's assumption. Now let's talk about subrogation. This is the transfer of the obligation from the obligee's perspective. This is the transfer of rights, right? So we're transferring rights. The definition of subrogation is the substitution of a third person for the original obligee. It's a substitution. This is different from assumption where we're adding people. This is a substitution, right? A substitution of one person for the rights of another. Now, if you have a full subrogation, guys, the third person steps into the shoes of the original obligee and completely replaces the original obligee, right? The original obligee is gone. And the effects of subrogation flow from that basic idea, that basic definition, all right? So first, a subrogation, this is what goes in the handout, extinguishes the original obligation for the original obligee. It extinguishes it for the original obligee. The performance is now only owed to the third person, right, the subrogee. Probably the most important effect of subrogation is that the subrogee, the third person, steps into the shoes of the original obligee for all purposes, including the ability to assert security interests like mortgages. Right, so you'll probably have an opportunity to see some examples of subrogation in old bar exam questions involving security rights, right? It'll come up there. When subrogation occurs, the third person, the subrogee, gets the benefit of whatever security interest the original obligee had, right? It's important to remember. Now again, there are two types of subrogation. There's conventional subrogation and there's legal subrogation. Conventional subrogation, of course, occurs by virtue of a contract. Legal subrogation occurs by operation of law. Right now, conventional subrogation, guys, this is probably more likely to come up on the bar exam. At least this is how I have seen it the most recently. Subrogation comes up in the conventional sense. And conventional subrogation can occur by an agreement between the third person and the obligor, or a third person and the obligee, right? Just like assumption can occur like this. Either party can agree with the third person for a subrogation. It is much more common that subrogation occurs between a third person and the obligee. In other words, it's much more common that the obligee is consensually transferring his rights, right? That just makes more sense. And this is so common that it has its own name in the code. It's called an assignment of rights, right? You're assigning your rights when you're an obligee and you give them to a third person. Right, so banks assign the right to collect money on loans all the time. Right? The bank assigns the loan, right? That's a subrogation, conventional subrogation by the obligee. The owner of real estate that is subject to a lease, who has the right to collect rent, can assign his right to the rent to someone else, right? Conventional subrogation by the obligee. These are circumstances in which you'll see this come up. Again, I think it was July 2014 where we had subrogation in the lease context. A lessor sold property to a purchaser. There was a lease affecting the property. The lessor subrogated the purchaser to his right to collect rent, right? And you had to talk about whether the subrogation was done appropriately and what the consequences of that subrogation were. All right, conventional subrogation can also occur between an obligor and a third party. This is much more unusual. I'm just going to sort of quickly walk through the rule. The way this type of subrogation happens is that the obligor borrows money from a third person to pay an existing debt, right? So we have an existing debt, the obligor borrows money, pays off the original obligee, and is now bound to the new obligee. Right, so we're substituting the rights of the new creditor for the old creditor. The key here, guys, the rule you need to know is that when this happens, when you borrow money to pay an existing debt, you're going to need an express written agreement between the obligor and the third person that subrogates the third person to the original creditor's rights. So you need that express written agreement for subrogation to happen in this way. Unlikely to see this, I think, but you should at least know the basic rule there. The last kind of subrogation is legal subrogation. This occurs by operation of law, probably the least likely kind of subrogation that you'll see on the bar exam, but of course it is still fair game. There are a list of situations in which legal subrogation occurs on page 10 and the top of page 11 of your outline. You can look at these now. When an obligee pays another obligee with superior rights, we are told by the code legal subrogation occurs. So if you have many, say, mortgagees sort of ranked in order and a lower mortgage holder pays a higher mortgage holder, subrogation occurs. You might be called upon to talk about that in the security devices context. The thing to know, the other one that's important to know is number 3. An obligor who owes a debt with others and has recourse against the others will get the benefit of subrogation when he pays the debt. There's an important case on this called Martin that appears here in your outline. The facts of Martin aren't as important as the holding, and essentially what it says is that this rule applies when obligors are solidarily bound. Solidarily bound. In other words, when you have obligors who are solidarily bound and one of them pays, then that obligor is subrogated to the rights of the creditor against other solidary obligors, right? So that's subrogation by operation of law. Again, know the instances in which legal subrogation occurs, read through the list, be familiar with those, but what you really need to focus on is conventional subrogation. I think that's more likely to be tested. All right, finally, on subrogation, there's an important distinction between legal subrogation and conventional subrogation that you need to be aware of. And that is, under legal subrogation, the new obligee can recover only to the extent he has performed. Right? So when you are legally subrogated, you recover only to the extent you have performed. But in conventional subrogation, guys, you can be subrogated to the entire amount of the original debt, even if you don't pay the entire amount of the original debt. The hypothetical that's in your handout illustrates this point. So let's say Jill owes a debt of $100 to the bank, Bank A, right? Jill owes a debt of $100 to Bank A. Bank A sells the right to collect the debt to Bank B, conventional subrogation by the obligee, right? Bank B pays $80, right? Pays $80. And this makes sense, right? Because Bank B is going to try to collect the whole thing and make a little profit. Why else would Bank B buy the debt if they didn't think they could make a little profit? They're always going to pay a little discount for that. The law says that even though they've paid less than the full amount, they're subrogated to all of the original creditor's rights, right? The full amount. So Bank B is entitled to collect the full $100, even though Bank B only paid $80 for this right, right? That's an important rule to remember. All right, that brings us to the end of transfer of obligations. We're going to move on now to talk about proof of obligations. This stuff is nice because it's relatively easy. It's super important for the bar exam though, guys. Like, you have got to know each and every one of these rules under proof of obligations. They are always tested on the bar exam, right? The proof of obligations rules are low-hanging fruit. Memorize them. All right, so when you claim that an obligation exists, you have the burden of proving it, right? That's a thing. So sometimes to prove an obligation, we require some kind of heightened formality, right? A writing of some kind. And when a writing is required by the law, the obligation cannot be proven without that writing, right, by oral testimony, unless, this is the exception, the instrument has been destroyed, lost, or stolen. So if the law requires a writing or some other form, you cannot prove the existence of the obligation by oral testimony unless the instrument was destroyed, lost, or stolen. The instrument has to have existed in the first place, right? And then it disappeared in some way. Now, there are three types of writings in Louisiana, some with more requirements than others. And I know that we're sort of partially through our coverage of the Barbary material at this point, beginning of June. And so you've talked a lot about form, I think, in the other portions of the material you've covered, but we're going to talk about it in its kind of most basic sense. And again, form is routinely tested on this part of the bar exam, so it's important. All right, so first, the most heightened form in Louisiana law and the general rules is the authentic act, right? Again, we're not talking about wills, which I know you've already covered, but just, you know, for contracts, the authentic act is going to be the most heightened form. The authentic act, of course, is executed in the presence of a notary and two witnesses, right? So you've got to have a notary and two witnesses. You know already that some transactions can only be accomplished by an authentic act, right? If you don't have an authentic act, you have a nullity. This is the case, for example, with a donation inter vivos of an immovable, right? You have to have an authentic act for a donation inter vivos of an immovable. All right, the next kind of form that is sometimes seen in the law, this is less frequently seen than the other two, is the act under private signature that has been duly acknowledged. The act under private signature duly acknowledged. This is an agreement that is not originally executed before a notary and two witnesses, right? The parties don't sign it in the presence of a notary and two witnesses, but later they take the document to a notary and execute an affidavit or a certification before a notary and witnesses, swearing that the signature is theirs, right? So it's not executed in the presence of the notary and the witnesses, but it's later, quote, duly acknowledged, right? So it's a little less heightened of a form because you don't need the notary and the witnesses there to begin with, but you get them eventually. Now, in many kinds of transactions, this can be just as good as an authentic act, right? So for example, a matrimonial agreement can be made by act under private signature duly acknowledged or an authentic act. Either one suffices. But remember, if the law requires an authentic act, like for a donation inter vivos of an immovable, you got to have that authentic act. The act under private signature will not suffice even if it is duly acknowledged. So you've got to know those form requirements for individual transactions cold, right? The last form requirement that we need to discuss is the plain act under private signature, right? Just an act under private signature. This is just a written instrument that is signed by the parties, right? It's just a writing. It's signed by the parties. Whenever the law says that something has to be in writing, what we need is an act under private signature. Now, the code says that this type of act need not be written by the parties, but must be signed by them. So this doesn't have to be handwritten or typed by the parties themselves. This is a reflection of the recognition that documents are frequently typed by, secretaries, attorneys, other individuals. We download forms from the internet, whatever. But as long as the document is written and signed by the parties, right, we are good to go. Now, there's an important nuance here, though, that you need to be aware of. The code says that the act under private signature must be signed by the parties, plural, like both parties have to sign the act under private signature. That's the rule in the statutory language. However, there is a huge, enormous jurisprudential exception to this both parties sign rule that is recognized in the comments to the articles. The jurisprudence permits a writing to be signed by only one party if the other party avails himself, that's the language you want to write down, avails himself of the contract by his conduct, right? So one party signs, the other party acts. When we have that circumstance, we can have a valid act under private signature, a valid contract, even though both parties didn't sign. Guys, this comes up all the time in sales of a movable property, right? All the time in sales of a movable property, the transferor, the seller, will sign the act of sale and the buyer pays the price. Buyer might not sign. That's okay. In some parts of the state, that's just how this is routinely done. So the conduct of the buyer stands for the signature. All right. Now, we have a handle on what the requirements are, the 3 different types of forms in Louisiana, and we're going to run through the scenarios in which a writing is required. This is at the top of page 12. Now, you already know from Code 1 that a transfer of ownership or another real right in an immovable requires a writing. All right, so this is an important rule. It is tested all the time on the Code 3 exam. I cannot think of a Code 3 exam where this does not come up in some form or fashion. You're at least going to have to recognize that this contract of sale, right, of an immovable is valid because it was made in a writing. Now, I have something I want to say about this. I want you to listen to me. Stop writing. Listen. Look at me in the face. A transfer of an immovable requires an act under private signature. An authentic act is not required. It's just not required. I don't know where it comes from, but every year in my sales exams, I have a substantial number of students who tell me an authentic act is required for a transfer of an immovable. In an onerous contract, in a sale, all you need is an act under private signature. That is all you need. Do not mess that up on the bar exam. This is an easy thing to get right, right? All you need is an act under private signature for an onerous transfer of an immovable. Got it? Okay. Now, the other thing I want to say about this is that there is an important exception to the rule that you need a writing, right? There is, in fact, a way to have an oral sale of an immovable. And you guys forget this all the time. I mean, not you, but the collective. You do too. You all forget, right, that there's an oral sale of an immovable. Now, you have to meet 2 requirements to have a valid oral sale of an immovable. What are they? First, there must be actual delivery of the immovable to the transferee, right? So the transferee has to be in possession of the immovable. And second, the transferor has to admit the transfer under oath. Under oath. right? Now look, this doesn't happen a whole lot, right? We don't have many cases on this, but occasionally it comes up, both in the jurisprudence and you got it on the bar exam, right? Where we'll have a situation where we have an oral transfer of property, the parties agree verbally, right, to the sale of real estate. The buyer takes possession of the property, later there's a legal dispute, and then the seller ends up admitting under oath, right, in a deposition, for example, that the sale occurred. Voila, we have a valid sale, even though there is not a writing. Don't screw that up. Okay, so what do you need to know about the sale of an immovable? It has to be in writing, just need an act under private signature. We do not need an authentic act. And there's even an exception for the oral sale, verbal sale of an immovable, provided both requirements are met. All right, now those rules, guys, are just for effectiveness between the parties, right? To bind third parties, of course, we have a recordation requirement, right? This is where the public records doctrine comes in. Now look, for a long time, there weren't any questions about the public records doctrine on the bar exam. But now, I mean, in recent history, the public records doctrine is all over Code 3. It is all over Code 3. You got to know the public records doctrine. All right, so what's the deal here? Well, in Louisiana, we have a pure race doctrine as opposed to a notice doctrine, right? So that means the first to file has rights. Knowledge of an instrument is not sufficient to bind third parties, right? Knowledge of an instrument is not sufficient. An instrument has to be filed for registry. That's the language you want to use in the handout and on the bar exam. Filed for registry in the appropriate records. What are the appropriate records? You need to be able to discuss this on the exam. The appropriate records has to be in the parish where the property is located, right? Parish where the property is located. We do not have a statewide central recording system in Louisiana, right? So if you buy a movable property that's located in Jefferson Parish, in order to bind third parties, you got to record in Jefferson Parish. If you record in the wrong parish, it is as though you never recorded. Has absolutely no effect if it's in the wrong parish. Bar examiner loves to test you on that, parish by parish requirement. Another thing the bar examiner loves to test you on. In all of the parishes, we have a sort of dual recording system, two different sets of records, one for conveyances and another for mortgages. We have conveyance records and mortgage records, right, in every parish. In order for recordation to be appropriate, it has to be in the right set of records, right? So a sale, even a lease of an immovable, has to be recorded in the conveyance records, not the mortgage records, to be valid against third parties. If it's filed in the mortgage records, it's as though it was never filed at all. Has absolutely no effect. That was a sort of nitpicky point that wasn't tested for a long time. Bar examiner has started routinely testing on this. Trips you up because he gives you the right parish, but then mentions that it was recorded, a sale or a lease was recorded in the mortgage records, right? And vice versa, if you have a mortgage, it better be in the mortgage records and not the conveyance records, right? So pay attention to that. All right, again, if an instrument is not filed, the instrument is not binding on third parties, right? And what you want to remember about the public records doctrine is that it is a negative doctrine, right? Parties are allowed to rely on the absence of things from the records, right? It's the absence of things from the records that we're concerned with. All right, finally, on proof of obligations, you're going to want to know and memorize the other situations where a writing is required, right? We require a number of instruments to be in writing, and these are discussed on the bottom of page 12 and the top of page 13. We've already talked about transfers of immovable property. Let's talk about some of the other ones. All right. Number 2, a mandate authorizing the transfer of a movable property must be made in writing. A mandate. Guys, if you're trained in the common law, a mandate is the Louisiana term for agency. We're going to cover this tomorrow. We're going to talk about mandate and all the rules governing mandate. What you need to know now is the form. Generally, there's no form requirement for a contract of mandate, but if you make a contract of mandate authorizing the mandatory to transfer immovable property, then the contract of mandate has to be in writing, right? It's an equal dignities rule here. Whatever the underlying contract form requirement is, that applies to the mandate. The promise to pay the debt of a third person must be in writing. That's an important one, tested occasionally. A promise to pay a debt extinguished by prescription must be in writing. We've talked about that one already. It's important. Number 5 is also important, a compromise. A compromise, that's the civil law term for a settlement. It must be in writing, generally. There's a question recycled fairly often on the exam where there's a debt. One party sends a letter with a settlement offer. The other party phones in an acceptance. Valid compromise? No, right? No, because we don't have a writing on both sides, right? That act under private signature. There's an exception to this rule that a writing is required for a compromise. We're going to talk about it some more tomorrow. But a compromise can be made verbally if the compromise is recited in open court and capable of being transcribed from the record. Right? So generally a compromise must be in writing, but of course if you make that compromise in open court and it can be transcribed from the record, then it is still valid. All right, finally a suretyship agreement must be in writing, right? Oral agreements don't work. And you'll talk more about suretyship when you cover security devices. All right, the last thing about proof of obligations here under letter E is important. It's the parole evidence rule, right? So under this rule, testimonial or other evidence may not be admitted to negate or vary the contents of an authentic act or an act under private signature. You can't dispute the contents of a written act with oral testimony generally. You need a writing generally to disprove or negate a written act that is signed by the parties. Right? But there are some exceptions here, and these are set forth here on page 13. Right? In the interest of justice, parole evidence may be admitted to prove evasive consent, right, such as an error of one of the parties. Surely you can use parole evidence for that, fraud, or to prove that the act was modified by a subsequent and valid oral agreement. Right, so keep in mind what's happening here with this subsequent modification thing. Unless the law requires a contract to be in writing, right, then it can be made verbally. And if the parties happen to make the contract in writing, they are still authorized to modify the contract verbally, right? So if we have a contract not required to be in writing, but in fact is in writing, parties can introduce parole evidence to prove that the contract was verbally modified, right? That is entirely permissible. All right, we've come upon now our last topic for today. This will take us through the end of the outline on obligations. And that is extinction of obligations, right? So how do we bring an end to obligations? All right, there are a number of ways to end an obligation. We're going to go through each one of these in turn. First and foremost, an obligation can be extinguished by performance, right? Performance extinguishes an obligation. Once the obligor renders performance, it extinguishes the obligation. The obligation no longer exists. The key thing here to remember, the trick, is that this is true even when the performance is rendered by a third person, unless the obligation was strictly personal, right? So the original obligor is off the hook if a third person renders performance, as long as the obligation was not strictly personal. Now, the only complicated part of this performance stuff is that there's a system for imputing payments on debts that is set forth both in the code and in the outline on page 13, right? So when an obligor owes more than one debt to the obligee and then makes payments, we have to figure out what payment to apply, what debt to apply the payment to. I'm not going to go through all these rules with you because number one, they're complicated and you just need to read through them and become familiar with them. Number two, they've never been tested. Never been tested. And number three, there's a rough rule. I know I told you a gist won't suffice, but here again, I think a gist might do the trick. There's a rough rule that you can go with that will take care of most situations. All of the rules on imputation of payment basically say essentially this. We boil them down to this. The obligor can designate which debt he wants to pay, right? So if I owe multiple debts, I can say, here's $100, apply it to loan A, right? I can designate the debt. If I don't designate the debt, then the default rules in the code generally apply the payment to whatever debt the obligor would most likely want to have paid. Would most likely want to have paid. It's going to be the debt that's the most onerous, the one with the highest interest rate, or the one with the strongest security. So it's whatever debt the obligor would most likely want paid, right? So the default rule is the obligor can designate the debt that he wants paid. If he doesn't designate, it's generally whatever debt he would most likely want paid. All right, impossibility of performance. This is an important topic. It is tested relatively frequently. Impossibility, guys, occurs when a fortuitous event makes performance impossible, right? Those are two ideas we need to focus in on here for this section of material. Fortuitous event makes performance impossible. When a fortuitous event makes performance impossible, the obligation is extinguished, right? No more obligation. All right, so first, a fortuitous event. This is a term of art, right? This is an act of God or a force majeure that excuses non-performance, right? Again, we're looking for a fortuitous event. All right, so what is a fortuitous event? This is defined by the law as an event that was not reasonably foreseeable at the time the contract was made. Not reasonably foreseeable at the time the contract was made. This is a highly fact-based determination. Remember when I told you the examiner is going to want you to argue both sides of an issue? Whether an event is fortuitous, who knows, right? Talk about the possibilities if you see this come up. Sometimes you get close calls. All right, so here's a hypothetical that'll illustrate this idea of fortuitous events. Let's say Jack agrees to paint Jill's house by the end of the week, right? I'm going to paint Jill's house by the end of the week. Before Jack performs, heavy rains occur, right? Pours rain. Is Jack's obligation to paint Jill's house extinguished due to the rain, right? Well, it depends on whether the rain is a fortuitous event that makes performance impossible. All right, so first, was the rain a fortuitous event? Was it unforeseeable at the time the contract was made? I don't know. You don't know. Probably not, right? Probably not. We're in Southeast Louisiana. It rains all the time, right? But you would need to set forth the rule and then talk about whether it was foreseeable. You might have some facts in the fact pattern that help you lean one way or the other. Now, the other key here is that not only does the event need to be fortuitous, but performance must be impossible, like actually, truly, physically impossible. It does not suffice that performance is simply made more difficult, right? It has to be actually impossible for the parties to perform, right, in order for extinction of the obligation to occur. And so you would want to talk about that fact question as well on the exam. Great fodder for nuanced fact analysis that our bar examiner loves. All right, now there are some exceptions to the impossibility doctrine that you need to know. This starts at the bottom of page 13. Assumption of the risk is one, right? Certainly the parties can discuss and contract around impossibility, right? They can have what we call hell or high water clauses, right? I will perform no matter what. Come hell or high water, I will perform. Which means that when hell or high water comes and they can't perform, they're in breach, right? They're in breach of contract. And that renders the whole concept of impossibility inoperative, right? You'll recall that there are lots of rules in the Civil Code that are suppletive, right? That can be contracted around. The rules on impossibility are examples of suppletive rules. So what do you want to say on the bar exam? If the parties contract around impossibility, you want to say the rules on impossibility are suppletive rules that the parties may contract around, and here they have done that. Assumption of the risk negates the doctrine of impossibility, right? Another exception to the rules on impossibility, top of page 14, right? If the obligor has already breached and has been put in default at the time the impossibility arises, then the obligation is not extinguished for impossibility, right? So if you've already breached and been put in default, right, so the risk's on you. We're going to discuss putting in default more tomorrow. All right, finally, the effect of impossibility. Of course, if the entire performance is rendered impossible, then the contract is completely dissolved, right? If the entire performance is rendered impossible, the contract is completely dissolved, but sometimes performance is only rendered impossible in part, right? And when that occurs, the court can scale back the contract and order a modified performance, right? All right, next, another way to extinguish an obligation is novation. Novation. This is actually the extinction of an existing obligation by the substitution of a new one. So we're not only extinguishing an obligation, we're adding a new obligation, right? So sort of like a 2-for-1 kind of thing. So a novation simultaneously extinguishes and creates rights. Important to know. The most important thing to know about novation is its consequences, right? They're harsh, right? They entirely extinguish a debt, and then they create a new debt. And this ends up sort of modifying whatever attributes the original obligation had, because the original obligation is gone. Now, because a novation is such a big deal, we need intent to novate, right? We always want to make sure we have clear intent to novate. The law requires clear and unequivocal intent to novate. Any small change in the obligation, what the law calls a mere modification, is not going to be enough, right? We have to have clear and unequivocal intent to novate an obligation. Now, if there is intent to novate present, if that is satisfied, and there actually is a novation of obligation, then what we have is the creation of a new obligation, right? A new obligation. And the way this happens, guys, is we either substitute a new performance or a new debtor, a new obligor. We either have a new performance or a new obligor. If we substitute a new performance, then what we have is called an objective novation. Objective novation, because we've changed the object of the obligation. So it's an objective novation. Now, the old examiner used to love to test this, and again, the new examiner is recycling some of the old questions. And the way that he would test this is with what is called a giving and payment. A giving and payment. You might remember this from law school. We'll talk about it more on either tomorrow or Wednesday. But what happens here is that you have parties who are already involved in a contract with a money debt, right? So an obligor owes cash to an obligee. And instead of paying cash, the parties agree that the obligor will give something of value to the obligee, right? So I owe you $100,000. I don't have $100,000, but I have this tract of land that's worth $100,000, so I'm going to give you this tract of land. When we agree to do that, we novate the original debt. We have a giving in payment, a giving in thing, a giving of a thing in payment. And it's an objective novation because we've changed the object of the obligation. Got it? All right. A subjective novation, on the other hand, occurs when we substitute a new debtor for the old debtor, right? So when we change out the obligors, right? Now be sure you're able to distinguish this from an assumption. This is kind of like an additional step after an assumption occurs. So remember, we said as long as an obligation is not strictly personal to the obligor, we can transfer duties from one obligor to another through an assumption. When we have an assumption, we add a new obligor, and the old obligor and the new obligor are now solidarily bound together. However, if the parties agree, right, that the new obligor is going to substitute for the old obligor, the original obligor is off the hook, right? So that's not merely an assumption, it is a subjective novation, right? You got to have that extra clear and unequivocal intent to release the original obligor to have that kind of novation, right? And it's going to impact whether the original obligor is on the hook still. All right. Again, one of the most tested things about novation is effects. This is number 2 under letter C on page 14. If you have a novation, the original obligation is entirely extinguished, totally extinguished. All of the rights associated with the original obligation are gone. And you know, you'll review this again probably when you talk about security rights, but security rights associated with the original obligation disappear, right? That's one of the reasons why novation is such a big deal, because if we find a novation, then the general rule is that those security interests, those accessory contracts, fall away, right? And that can be harmful to the obligee. All right, the next thing we need to talk about is remission of debt. Remission is yet another cause for extinction of an obligation. We've already talked a little bit about remission when we talked about solidarity, right? Remission is a voluntary relinquishment by the obligee of the right to demand performance, right? So you voluntarily give up the right to demand performance. This can be done for gratuitously, never mind, you don't owe me anything because I like you so much, or this can be done in an onerous contract, right? Or perhaps a compromise, right? Where you're getting something in return. Either way, it's a voluntary relinquishment. All right, so don't forget the rule that we discussed when we talked about solidarity, that remission is presumed when the obligee gives the obligor whatever instrument evidences the debt, right? We have a presumption of remission when you give up the instrument. There's a famous case in the jurisprudence, you may have read it in law school, about a mom who sells property to her son on a credit sale, and she has all these promissory notes that represent the price, and then every year she hands him a note, right? And he's not paying the price, she's over time forgiving the debt, right? There's a presumption of remission when she hands over the instrument. And again, that makes sense because that instrument, that's how you prove the existence of the contract, right? I need the instrument to go to court and prove the contract, or at least it helps me greatly to have it. And so if I'm handing you the only means of proof that I have, I must intend to release you from the debt, right? To remit the debt. It's not a deeming, you can rebut the presumption, but it's a presumption. All right, now another thing to remember about remission, especially you common law folk, is that remission is considered a contract at civil law, right? Even when it's gratuitous, it's a contract. So that means we have to have offer and acceptance, right? Now the key here is that because remission is always so great for the obligor, for the party who's getting remitted, that we usually presume acceptance, right? So we presume acceptance, it can be rebutted. Essentially the obligor can reject the remission if he would like to have that debt on his balance sheet for some reason. He might want to reject, but otherwise we presume acceptance. Now at the top of page 15, there's some rules here for sureties. You'll discuss this, no doubt, when you cover suretyship in a couple of days. But a remission of the principal obligor lets all sureties off the hook. Remission of a principal obligor lets all sureties off the hook. This just a specific application of the general rule that when a principal obligation falls, its accessory contracts fall as well, right? Just remember the converse is not true, right? When we remit sureties, we don't necessarily remit the principal obligation, right? Easy. All right, the next way to extinguish an obligation is compensation. Compensation, this is like offset at common law, guys, but you won't say offset, you'll say compensation, right? You're going to use the civil law term. Now, compensation actually extinguishes two obligations simultaneously. Simultaneously, that's the word you want to put in the handout, simultaneously. So this can happen in one of two ways. First, it can happen automatically as a matter of law, right? Automatic compensation as a matter of law. The elements at the top of page 15 have to be met in order for this to occur. First, we need to owe identical things or sum of money to one another, right? We need to owe identical things of sum or sums of money, right? So if I owe you $500 and you owe me $500, compensation can occur, right? Generally as a matter of law because the debts are identical. If I owe you 100 oranges and you owe me 5,000 apples, we can't compensate there, right? Because we don't owe each other identical things or sums of money, right? So compensation first requires identical things or sums of money. In addition, second requirement, got to meet it. The debts must be liquidated and presently due. Liquidated and presently due. So we have to know how much, right? We need some certainty, and the debt must be presently due, can't be affected by a term. So in order for compensation to occur by operation of law, we need identical things or sums of money, and the debts must be liquidated and presently due. So here's my hypothetical. Jack owes Jill, a debt of $500, $500 money debt. Before Jack pays, Jill rear-ends Jack's car, causing property damage, right? So he wrecks her car, or she wrecks his car, Does legal compensation extinguish these debts? No, right? No. The first prong is met. We have money debts, right? I mean, they both owe each other money, so at least we could have partial compensation. But the tort debt, the car wreck debt, that's not liquidated yet. It's not liquidated yet. Right? We don't know how much is owed because we don't have that quantified. Now, if you look at the bottom of page 15, a judge can order compensation. A judge can order compensation even if the requirements we've already discussed are not met. And what happens here essentially is that the judge makes the requirements become met. Right? So in other words, in my tort debt example, even though the tort debt might be unliquidated, a judge could look at the case, determine the value of the tort debt, render a judgment, and then render a judgment of compensation. Right? That could be appropriate there. So even when compensation does not occur by operation of law, it can occur by judicial decree. All right, the very last thing we need to talk about, guys, and then we'll be done for the day, confusion. Seems appropriate to end the day on confusion, does it not? All right, finally, confusion extinguishes obligations. Confusion results from a party becoming both obligee and obligor, right? So the same party becomes obligee and obligor. Confusion exists, this is for the handout, when the qualities of obligor and obligee are united in the same person, right? It doesn't make any sense for somebody to pay himself, right? So we just say the obligation is extinguished. Guys, common law folk, this is the equivalent of merger, right? But don't say merger, not gonna say merger, you're gonna say confusion. Now this has actually never been tested on the bar exam, which is surprising because it's, civilian. But the important thing to remember is that confusion requires the same person for obligor and obligee. The last little note is that for both compensation and confusion, for both of those kinds of extinction of obligation, the same rules about accessory and principal contracts apply, right? Again, I'm sure you'll talk about this in security rights, but if compensation or confusion extinguishes a principal debt, the accessory obligations fall with it. They are also extinguished, but the converse is not true, right? So keep that in mind. All right, guys, we are done for the day. We will pick it up tomorrow with contracts. If you have questions about any of this material, please don't hesitate to email me. I'm happy to chat with you about any of the outlines or the model answers to the exams. All right, see you tomorrow.